Attorney Anthony Bruskel, representing the plaintiff, Bradley Clare. Is Mr. Clare present this morning?
No, Your Honor. Judge, I haven't actually had any contact with Mr. Clare probably since we finalized the divorce, which I guess could mean that everything's going fine. I haven't heard from him or the other party at all. So when I met with Aaron, I just indicated that because everything was entered on a temporary basis without prejudice, that I was asking for everything in the judgment to remain as is until further petition by one of the parties.
Very well. And Melody Clare is also not present. Is that correct?
To my understanding, that is correct.
Very well. Well, thank you for appearing this morning, Mr. Bruskel. I hope you're doing well.
Feeling good, Judge. I hope you're feeling well also.
Taking one day at a time.
Yes, sir.
Very well. Good morning, Ms. Brower. Can we prepare maybe just an order saying that neither party, Mr. Bruskel appeared, but neither party appeared?
There is a recommendation in your queue. I did make note that neither party failed, or that both parties failed to appear, and that we leave custody and parenting time for the judgment of divorce. Perfect.
Is that acceptable, Mr. Bruskel?
It is, Your Honor. Thank you.
Wonderful. Thank you, Ms. Brower. All right, Mr. Bruskel, have a great rest of the day.
You too, Your Honor. Thank you for your time.
Thank you.
There are other matters on 10:15, so she's going to tell you what's supposed to be on for today.
Good morning, Stephanie. My condolences on your grandfather. Lost your grandpa.
Thank you. It was a very long weekend. A lot of time in my car.
The colors changing in the UP?
They're starting to. They're not real pronounced yet, but they are starting to.
How old was your grandfather?
94. He would have been 95 on the 14th.
Oh.
Yeah.
Well, we were fortunate to experience our grandparents. I was blessed. I knew both sets of grandparents.
Absolutely.
Of course, Monday was Grandparents' Day. So I went, they had, I think they were at St. Michael's. I know Julie was active too. So it's wonderful. I think grandparents play an important part of lives of their grandchildren.
They do. They do. And they're terribly missed, even if they were almost 100 years old.
Yeah. So what's going on with Ott? I don't.
So I have an objection that was given to Ms. Hicks because it was an objection to referee McKee's request for a bench warrant, and it was filed by Christopher Ott's attorney. I know there's other matters that are scheduled next week, but we didn't receive anything saying that this was being pushed to next week, but if it is, that's fine.
Steph, I think there is one in the file.
Oh, because when Rebecca and I were looking at it, all we saw was the notice of hearing on the show cause that Miss Kuhn filed.
I don't know anything about it. I don't. Oh, what's the file up here for?
We were checking on it.
It is one of the notice of rehearings, Stephanie.
But it's on and off, on and off, on and off.
6 down in the legal.
Your order says 10:15, my email says 10.
Okay.
Oh, I see, because the proof of service was ahead of it.
Yep.
Well, this one wasn't scheduled for 8:30. Okay, so apparently it's next week at 9:30. I'll put a note on it for Miss Hicks.
Okay. Yeah. And the mind matter's off too. Steve Rosenberg's mom passed away. She lives up in, I think, Toronto or somewhere in Canada.
Oh, unfortunate.
So that matter's been forward till next week. So we have nothing till 9:30. Yeah, we'll call it 9 o'clock matter.
Okay.
Catherine Vine versus William Vine.
For the record, this matter is before the court on the plaintiff's motion for temporary initial orders of relief. Both parties represent legal counsel, and they've agreed to adjourn this matter to October 15th at 11:15 a.m.
On the matter of Amanda Sorter versus Devin Martin.
For the record, this matter is before the court on the plaintiff's motion for order to show cause, requesting that the defendant, Devin Martin, be held in contempt for failure to pay child support. This hearing is being conducted via Zoom. It appears both parties are present. Ma'am, you're Amanda Sorter, is that correct?
Yes, sir.
And sir, you're Devin Martin, is that correct?
Yes, sir.
Right. Mr. Martin, are you currently employed?
Yes, I just told Mr. Walker I just had got back to work 2 weeks ago. That's why I indicated by the 28th, I can at least pay October's. I'm not guaranteed, but I can try to pay $800, which would cover September and August payment, but for sure, at least October's, which I've been paying for, which is it's been a little bit over my support obligations. I know not much, but the support obligations was $382 a month. Plus I have 2 other cases also. One being out of Monroe County, and then my other one out of Lucas County. And then in the process, I have to get out of where we are because, they haven't done it, but they're basically, yeah, we have to move because, we haven't been able to afford it. It's been rough, for everybody. I understand it's rough for everybody. But I've been trying.
Court's understanding the arrears are about $5,000.
Yes.
Yeah, that's my understanding. Like I said, I told Mr. Walker also, I think it was back in like March, maybe earlier this year when we had a hearing. There wasn't no current support, which I didn't even know they had stopped it from back when I had got locked up, but they started the support up and then must have ran it back or whatever, which is being why they got so much higher, because it was only about $2,000.
Well, you should meet with your caseworker, Mr. Martin. They can give you an audit. They can print out exactly how they arrived at this average of $5,000. And then, Ms. Horvath, you and Mr. Martin been able to talk through this. You're asking to be able to contempt in jail. Of course, if someone has served time in jail, they many times lose their job, and then it creates more problems. Mr. Martin has suggested he can make significant payment on the 28th of this month. Do you have any objection to adjourn this matter till the last week of the month?
Your Honor, this happens every time I come to court.
Okay, Ms. Order, are you opposed to adjourn this matter till the end of the month?
And then do I see you again? Because he ain't going to pay.
I'm sorry?
Will I see you again at the end of the month? I would rather just have him pay the $5,000 today.
Well, that's not going to happen. Obviously, you can't get water out of a rock, Miss Sorter. So I guess the question is, do you want the court to proceed with contempt this morning?
Yes.
Or do you want to adjourn the matter till the end of the month? And yes, it can be before this court. We can adjourn back before this court. Mr. Martin has indicated he can pay a minimum of $800 by then. And then, Ms. Sorter, do you want the court to proceed with this morning?
Let's put him in contempt.
I'm sorry?
Contempt.
You're asking the court to proceed with contempt this morning. Is that what you're asking?
Yes.
All right. So, Mr. Martin, the court had a couple questions. The court entered an order on July 9th, 2024. That order ordered you to pay $200 on July 12th and current support of $328 each month thereafter, and to provide verification in front of the court of 3 job contacts every week. Now, the court informed you have not done that, Mr. Martin. You paid $600 on July 31st, but there's no payments been made in August or September. Would you agree with all those statements?
I talked like I said, the last time that we were in front of Miss Hicks, which she said that she was setting the show calls aside because that I was paying. And then, like I said, I had got laid off. Work's been hard.
Mr. Martin, the question is, do you acknowledge that the court entered an order on July 9th? You already paid $200 on July 12th. You didn't do that. You already paid current support of $328 and provide verification of written verification of 3 job contacts every week. Do you acknowledge that was ordered by the court back then?
I believe so. That's why I paid the $600.
Did you provide, Mr. Walker, does your office have copies of any job contacts that Mr. Martin made written job verifications with employers, 3 per week from after July 9th?
I had got back to work.
No, Your Honor.
All right. So Mr. Martin, because you've not complied with that order, the court will commence contempt proceedings. Contempt is punishable up to 45 days in jail. Since there's possibility of jail, a distinct possibility you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Are you asking for a court-appointed attorney, Mr. Martin?
Yes, sir.
Okay. What's the name of your current employer, Mr. Martin? I need to ask you a few questions.
Ohio Pickling.
Pickling?
Yes, sir.
Pickling?
Yes, sir.
You've been employed there, what, just a couple weeks?
Yes, sir.
Okay. You get paid every week or every 2 weeks?
It's bi-weekly. So yeah,
Approximate,
every 2 weeks.
okay. So it's every 2 weeks. What's your approximate take home every 2 weeks?
I get paid, it's 18 an hour I get paid.
What's your approximate average take home every 2 weeks?
Hold on 1 second.
It's approximate.
Approximate, like after tax and everything, I think it's rough, maybe $1,000.
Do you have any other income?
No, sir.
Do you own any property of any value other than an automobile?
No, sir.
Snowmobiles, boats?
No, sir. I don't have nothing.
All right. Court's going to grant your request, court by attorney. Mr. Martin, give me a cell number that the attorney can reach you at.
419.
Okay. So when do you next get paid, Mr. Martin? Because the court's going to set a date, and you're required to personally appear in this court. Do you get paid on, you say, twice a month?
That's why I told,
You get paid this Friday or the following Friday?
the 18th.
Okay.
That's why I told Mr. Walker by the 28th, I will make sure I pay at least 800.
Okay, what time do you pay? Do you get paid in the morning?
It varies. Normally it's in the afternoon. By the time I get off, like on a Friday, you guys are closed. So that's why I said on the 28th. So on a Monday, I can make sure I come up there first thing Monday morning and pay.
Okay, I'm gonna have you to come in. You're gonna come in person, Mr. Martin. At 11:15, I'm just looking at the calendar, either the Friday the 18th or the Monday the 21st. So I'm asking, will you have been paid the morning of the 18th? It won't be till you won't get that check or that deposit till the afternoon. Is that correct?
Yes, it won't. Like I said, it varies on the employer and then my bank also. So the 21st,
Mr.
if you
Martin?
want to do that, the 21st, the morning of the 21st.
All right, Mr. Martin, you're to personally appear in this court, October 21st, 11:15 a.m. Personally appear. Miss Sorty, you can appear via Zoom.
Yes.
Court appointed attorney will contact you between now and then, Mr. Martin. So that's October 21st, 11:15 a.m. Please make note of that. Personally appear in Bronx on the 4th floor of the courthouse. Mr. Martin, the court's going to suggest you be prepared to pay $1,000 cash that morning toward your urges. And if so, the court will proceed with contempt, but I may not impose an immediate sentence. If you can't do that, then bring a toothbrush. So October 21st, it's a Monday, 11:15 a.m. Appear personally. And that's what the court's suggesting. You paid a minimum of $1,000 toward your urges on that date.
On or before?
Any questions, Mr. Martin?
On or before the 21st?
Correct.
Okay.
You said you're not going to be paid till the 18th. So that's
Right.
why I'm doing this so that you can make this happen so you can avoid immediate jail. But I'm going to keep you on a very short leash, Mr. Martin. That basically covers your urges for August, September, and October.
Okay.
So that's a minimum of $1,000. And there's no guarantee that the court will not impose an immediate jail sentence.
Yes, sir.
All right. So, Ms. Sorty, do you have any questions for the court?
No, thank you.
Okay. We'll see you on Monday, October 21st, 11:15 in the morning. Mr. Sorter?
Thank
All
you.
right. That will conclude this matter. You'll hear from the court appointed attorney in the meantime.
Thank you, Your Honor.
Welcome.
Your
You can
Honor,
zoom
I am
out. That'll
prepared.
conclude this matter. Do we have the plaintiff here this morning?
Back on too, but my FDR is not working.
Good morning, Mr. Leiter, Ms. Hicks.
Your Honor, good morning.
We're just, Sarah's having difficulty with the recording system. Mr. Martin, did you stop down in front of the court to make a payment? Okay, I'm just telling you. Okay, well, the attorney's been trying to call you. Mr. Martin just showed up. He's about 10 minutes late. Okay, Mr. Leiter, we're going to, do you want, I guess we can have Mr. Martin go down in front of the court, make a payment, talk with you?
That
Mr.
would be
Martin,
great,
okay.
Your Honor. I did try. I made exactly 3 calls this morning. I got the answering machine, all 3.
Can I see the file, please? We'll call it for case. Yep.
Okay,
Okay, we're having problems with the recording system, but look at the phone number that the court provided. So it's 419.
Yeah, that's it, Your Honor.
Okay. All right, the court wrote 6, obviously his phone number is 65. So maybe the court miswrote his number. Okay. Do you want Mr. we can have Mr. Martin step out and call you?
Your Honor, I'll give him a call. That's no problem whatsoever.
All right. So Mr. Martin, why don't you step out and you can talk to his conference room across the hallway, talk with Mr. Leiter. For just everyone's information, it's a private show cause matter. I think the court suggested Mr. Martin pay $1,000 today toward the rearages. Is that correct? Yes, sir. So why don't you go down and make that payment and talk with Mr. Leiter? I mean, the rearages are pretty significant if the court recalls.
She's not going to school. So support should be stopped.
Well, but this is Mr. Leiter's representing you on contempt only. He can't, maybe he can give you some direction, but you should talk to the front of the court caseworker. So go down and make that, go on and talk to Mr. Leiter. After you do that, go down and make the $1,000 payment. Mr. Martin, you might have to borrow gas money from someone else. Yeah, he's going to probably step out there, go down in front of the court and make that $1,000 payment, come back up and talk to the front of the court caseworker. They can give you a form motion. You might not need to file a motion to discontinue support. Right. He stepped out, Mr. Leiter, he's going to call you, and I think he's going to come down and make $1,000 payment. 6.
Thank you.
This is the state it's a private show cause. I'm surprised Mrs. Sorter's not here because she's the one who initiated this.
Your Honor,
Thank you, Your Honor.
it is the position of the friend of the court that this is not our show cause, as you stated, so we would not be pursuing or proceeding in any way without her present. It is her, it's similar to her filing a motion. If she doesn't appear for it.
Oh. Understand, we've already got a court-appointed attorney in place. I'm inclined to proceed. But obviously he's appeared today, so maybe we don't need your assistance in terms of a bench warrant since he has appeared.
Absolutely. I'm going to wait and hang out and see, and I'll make sure that he comes down and makes that payment so I can confirm it for you guys.
That'd be appreciated. And if so, the court would be inclined to find him in contempt, would reserve any sentencing, Mr. Leiter.
I think he's on the phone with him now.
All right.
I'm sorry, Your Honor. Go right ahead one more time.
Well, if in fact he makes that payment $1,000 today, the court's inclined to simply find him in contempt, but reserve sentencing, and sort of give him the key to the jail, and we'll put the matter back on Ms. Hick's docket.
Your Honor, I can't do that. The friend of the court would have to start our own show cause up. Our chain is closed because a private show cause was canceled. It can't just be placed back on my docket. We have to start the process.
Go out there and I'm going to shut it down and start it back up.
So what does it take to get it back?
Well, yeah, I'll have to reopen the meeting and do all that again.
Hold on,
I just
sir.
have Rebecca
talk with IT.
Lighter here, but
Hey, Sarah, we can hear you out here.
I know you should.
The rears are, I think, next has $5,000. I don't want to keep this on my docket forever.
Correct, Your Honor. The friend of the court has processes that we can follow
Okay.
once you are done with her private show cause, but we cannot do a show cause while there's a pending private show cause. So if
I
you
understand
make
that.
a final order in yours today, then it doesn't get just adjourned to our docket. We would have to start a new motion in order to show cause, which we can do.
Couldn't we put it simply on your docket for review?
No, because there's not an open docket with an open chain. That's not my chain has been closed.
Hold on, I'm not sure you may open chain, but we have an open case here. There's
Your Honor, I'd rather not keep discussing this while it's live streaming on YouTube.
Oh, okay. I didn't realize that. Okay. I thought Sarah couldn't do that. Talk with Patrice. I'm just trying to figure out how to handle this and try to keep Mr. Martin in line.
Absolutely.
Just trying to avoid her having to file another motion in 2 months from now. Okay. I didn't realize we're streaming. I thought she couldn't get us online. All right. Hopefully, Mr. Martin, you can confirm he made that payment. We'll go from there.
Yep. I'm going to go out and check that he's doing that now. Thank you. And I'll be right back.
All right. Thank you.
So Judge, I have to shut down the computer and start it up again because IT can't get it to come up either.
I didn't realize we're streaming to YouTube.
Oh, because I came out.
Shut us down, please.
IT. Hold on. I'm good. I gotta go out there.
Yeah, I didn't realize we're still on YouTube. For the record, this matter is before the court for contempt proceedings. Mr. Martin has personally appeared this morning as ordered by this court. Also, his court-appointed attorney, Mr. Timothy Leiter, is present on Zoom, as is Monroe County Front of the Court Attorney Rebecca Hicks. Good morning, Mr. Leiter and Ms. Hicks.
Your Honor, good morning.
Morning.
Ms. Hicks, the court recognizes this, of course, as a private show cause. Are you able to verify that Mr. Martin made a payment this morning of $1,000?
Yes, Your Honor, he did.
And with that payment, how much are the remaining arrears according to the front of the court records?
In total, $5,171.94.
And that was after the $1,000 payment?
That is correct, Your Honor.
Okay. Can you just, when was the last payment made prior to today?
July, Your Honor.
Thank you, Ms. Hicks. Mr. Leiter, have you had a chance to discuss the matter with Mr. Martin this morning?
I've had a
Yes,
chance
Mr.
to discuss this matter with Mr. Martin. Unfortunately, Your Honor, I think Mr. Martin is kind of more focused on, oh shucks, issues with his, I guess, his soon-to-be 18-year-old daughter, as opposed to the contempt. I did advise him that if he pled the contempt, I do believe, and if I'm speaking out of, if I'm not speaking correctly, Your Honor, please correct me, that there's an inclination to not impose any jail time, but just to set the matter for a review down the road with Ms. Hicks.
That's correct. Again, right now, I'm not sure how soon it will come up on Ms. Hicks' docket, but yes, any finding of contempt, the court would reserve sentencing. So the court would hand Mr. Martin the key to the jail, and he would not serve a day in jail unless he just ignored the request of the court. And Ms. Hicks, Mr. Martin has raised an issue. He needs to talk with his caseworker about getting formed to file a motion to abate support or terminate support, correct? If a child is attained the age of 18 and not going to school. And
I did speak with him at the window, Your Honor. I provided him with the motion packet as well as the document we had received from the child's school to indicate what her graduation date is, so he knows who to contact at the school about verifying and confirming whether she is in attendance or not.
Okay, so you'll need something in writing from the school that she's no longer in attendance?
Or for him to file the motion with it, correct, Your Honor.
Okay, but he will have to file a motion either referencing the date she vacated school, but hopefully have something in writing from the school. Is that correct?
That is correct, Your Honor.
Okay, thank you, Ms. Hicks. Right, Mr. Martin, do you understand? First of all, are you satisfied you've received the right to legal counsel by conferring with Mr. Leiter? Of course, he's representing you on this contempt only. Okay, if you, it's the court's opinion and intent that if you admit to contempt, you got arrearages in excess of $5,000. After this payment, the court would impose a sentence 45 days, but suspend that. And you would hold the key to jail. You would not serve a day in jail unless you put yourself in there. You understand that?
Yes, sir.
Okay. Do you want to talk with Mr. Leiter any further? I mean, you do not go anywhere until you go home today, back to work. Is it, are you satisfied again that you've received the right to legal counsel?
Yes, sir.
Okay. And you've got the form that somebody have to do on your own in terms of filing a motion to abate support, and definitely do that. Fill out the paperwork. Get that filed as soon as possible. Contact the school. So, Mr. Martin, is your intent to admit to contempt this morning?
Yes, sir.
All right. Please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony about the matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record.
Devin Martin.
Mr. Martin, do you admit and acknowledge that you're obligated to pursue the order of this court to pay support for the maintenance of children born to you in man disorder?
Yes, sir.
You admit and acknowledge that prior to your $1,000 payment today, you had, after your payment today of $1,000, you have silver arrears about $5,000.
Yes, sir.
Do you admit and acknowledge you have not made any payments since July of 2024?
Yes, sir.
Have you had any income during the months of August and September and October?
A few weeks ago, I had.
So you had no income at all during the months of August and September?
No, I mean, we're in the
How did-
process of moving, like I'm getting fixed, and I owe.
Okay.
I don't like to admit it as a man.
What efforts did you make to secure employment during the months of July and August, I mean, August, September?
I've been on.
Did you apply for unemployment?
I don't get.
Well,
I'm
you're unemployed.
Not on the books.
What do you mean? So you're paid cash on your prior job?
My brother, yeah.
All right.
Like self-employed.
So how did you buy groceries and pay your utilities during the months of August, September? Okay. Do you have any disability that prevented you from securing some type of employment, whether it's landscaping or otherwise, during the months of August and September? Okay. Mr. Leiter, do you have any questions, Mr. Martin?
Do not, Your Honor.
All right. The court finds in this case that a support order exists in this matter. The arrears prior to today exceeded $6,000. They've now been reduced to $5,000 by virtue of Mr. Martin's $1,000 payment. The fact that Mr. Martin did not make any payments during the months of August and September 2024. He has no disability, nothing that prevented him from making a payment or filing a motion to reduce the support. The lack of due diligence on the part of Mr. Martin is a basis in this court's opinion for a finding of contempt. According to this court, will find Mr. Martin to be in contempt of court. And the court does intend to impose a suspended sentence. Mr. Leiter, anything you want to say before the court imposes a sentence?
Oh, nothing further, Your Honor, other than we do thank the court, and I do thank Ms. Hicks for her help with this matter.
Mr. Martin, anything you want to say before the court imposes a sentence? Okay, so you have the court wants to be proactive, so definitely follow that motion. And again, that will apply to any future support, but you can't go retroactive. So you still got to deal with this 5,000 arrears. So at this point in time, the court's simply going to order these for 45 days in jail, but suspend that jail. Okay, and Ms. Hicks would let the matter take its own course, and correct. So after some period of time, if there's a couple months of no payments, then your office will start a show cause, or you'll
Correct,
send out notice for Mr. Martin to appear. All right. Okay. I think that will be sufficient. The court would note that Ms. Orr did not appear this morning. She was here on October 8th. So we will not schedule a future review at this time. We'll just simply let the matter take its own course. All right. Thank you, Mr. Leiter. Thank you, Ms. Hicks.
Thank you, Your Honor.
Thank you, Your Honor.
There's no future court dates. Obviously, if in fact there's no payments in the future, the front court will send you notice to appear. And then just make sure you appear, be proactive. That's all you need to do. And file that motion as soon as possible, because that will perhaps stop any future support. And whenever she left school, if you weren't aware of that, that's when you should have taken action.
Well, I'm not. Done with all her work for senior year.
Yeah.
You know, like.
Well, you get documentation she's going to graduate, because that will assist. At least talk with the schools.
What's that?
At least you talk with the schools to get some verification that she will in fact graduate.
Yeah, I am.
Okay. All right. All right. Thank you, Ms. Hicks, for checking in at the last moment. Appreciate it. For the record, this matter is before the court. The court recalls based upon parenting time complaints filed by each parent against the other parent. This hearing is being conducted via Zoom. Is Ashley Calhoun present on audio?
Yes, I am.
All right. Good morning. And sir, you're Matthew Hobson. Is that correct?
Yes, sir.
Ms. Sikorsky no longer represents you. Is that correct?
No, she does. She just wasn't able to make it. She sent me an email finally.
Okay. So you represent yourself this morning.
Yes.
Good morning, Ms. Brower. The two of you have confirmed with Ms. Brower from the front of the court as far as the court's fine recommendation. Well, I would think the court would like to think the two of you have more important things to deal with than coming back to court every other month. Just you gotta communicate, learn to communicate with each other. Your children are still 14 and 12. You had another, at least 6 years coming back to this court every other month. But in any event, Ms. Brower has made the following recommendation to the court. Ms. Hobson and Mr. Hobson, I'm sorry, it's now Ms. Calhoun. Anyways, father's current parenting time is alternating weekends, Friday at 5 until Monday to school or 9 a.m. if no school. And every Wednesday at 5 p.m. to Thursday to school or 9 a.m. if no school. Both parties are entitled to 2 non-consecutive weeks during the summer and shall provide 2 weeks notice of their intended week. And the front of the court holiday schedule is adopted. And that the parenting time complaints filed by each of you are both dismissed. That this resolves those parenting time complaints. This recommendation is sort of consistent with the last order of this court. Back on October 11, 2023. You were given, each were given non-consecutive weeks, during some with 2 weeks advance notice to the other. So this simply reiterates that. But I see father's parenting time. It seems, not sure what has changed, Ms. Bowers. This sort of just reiterates the prior order of this court. Is that correct? Or is there some change that the court's missing?
It has not changed, Your Honor. Mr. Hobson was under the impression that his parenting time on Thursdays ended at 5 p.m. And he states that his attorney told him a prior order was still in effect.
I do have the email.
So that is just clarifying that his parenting time on Thursdays ends at 9 a.m. if there is no school.
All right. The court's notes indicated Mr. Hobson's parenting time was every Wednesday at 5 p.m. to school Thursday morning, but we didn't provide a time if there's no school. So this simply clarifies that. So if there's no school, then obviously the exchange will be at 9 o'clock. Otherwise, there'll be 2 school.
Yep.
Clarifies that. All right, Ms. Calhoun, do you understand the recommendation this morning?
I do.
Do you have any objection to the court adopting this recommendation?
No.
All right, Mr. Hobson, do you understand the recommendation this morning?
Yes.
Do you have any objection to the court adopting this recommendation?
No.
Okay, so we simply clarify things. All right, the court will, thank you, Ms. Brower. The court will adopt the recommendation. Olivia is now 15. I had, she was 14. So your children are teenagers now, growing up fast. So please work together for their best interest and be flexible. If in fact there's an event at school or something, just communicate with each other so you can, make it work for each other. There's enough challenges in life. Don't make it more difficult for each other.
Okay.
With that, go adopt the recommendation, copy mailed to both of you. And that will conclude, sir, and you can both zoom out. Have a good rest of the day.
You too.
Thank you.
Thank you. For the record, this matter is before the court on account of an ex parte order entered by this court on September 18th, 2024, suspending defendant father's parenting time. The matter is before the court this morning for review of the defendant father's parenting time. This hearing is being conducted via Zoom. President Attorney Leslie Carr, representing the plaintiff mother, Raven Heflin. Ms. Heflin is present. In addition, defendant father, Jared Foland is present. Good morning, everyone.
Good morning, Your Honor.
Well, the parties have conferred this morning with Mr. Walker for the front of the court, who has provided the court with fine recommendation. The recommendation is that the ex parte order of September 18th, 2024 shall continue, remain in effect. The defendant father shall be allowed to have video chats, contact with the minor child supervised by the plaintiff on dates and times as parties can agree. And the parties will appear back for his court to review that parenting time November 20th at 10 a.m. in order to get more information regarding defendant's pending criminal matters and pending CPS investigation. That is a recommendation. Ms. Carr, the court was not aware of a CPS investigation. What is that about?
I just found out about the CPS investigation Friday. Your Honor, there's an investigation with respect to Mr. Foland's home and concerning specifically Mr. Foland. It is not involving my client or her child at this time, although CPS is interviewing them interviewing my client as a part of their investigation. But I did speak with the CPS investigator this morning. Amanda Neal is her name. And she informed me that there was some confirmed domestic violence in Mr. Foland's home, concerns about alcohol use, and that there is another potential criminal investigation that may be pending.
All right. Obviously, Mr. Foland, the court's primary concern is these bench warrants. You don't want to be driving a car. I don't know what the status of your license is, but you don't want to be driving a car transporting your 4-year-old and you get stopped for speeding or a minor violation, you get arrested in the presence of your child. That's obviously the biggest concern of this court.
I haven't operated a vehicle since I got my OWI.
All right.
I sold my vehicle afterwards.
Okay. Well, that minimizes that risk. But again, you need to take care of these bench warrants.
I went to jail Friday and paid them all, and I have court dates regarding all of them.
Okay. Have the bench warrants been set aside?
I bonded out of jail. They released me. Then
Okay.
they gave me court dates.
All right. They should be set aside then, the bench warrants.
Yep.
So we'll review this on November 20th, the status of these matters. Ms. Carr, does your client agree with this recommendation this morning?
Yes, she does.
I'm sorry?
She does, Your Honor. Yes.
There. Thank you. Mr. Foland, do you understand the recommendation?
Yes, Your Honor.
Do you have any objection to the court adopting this? And then we'll come back on November 20th, review parenting time.
No, I have nothing to say regarding the matters until it's resolved. or
Okay.
or have an attorney present for it.
Of course, you're not entitled to a court-appointed attorney because this is a civil matter.
Yeah.
The main thing is, and again, if you're currently involved in any type of alcohol counseling program, that's what the court would encourage that and provide, when you come back on November 20th, provide the court and Ms. Carr with a progress report from your therapist or counselor, that agency. That is very relevant.
Yes.
We just want you to the court wants nothing more than to establish a strong relationship between you and your 4-year-old. And obviously we want you to be healthy and be doing well. So the court would strongly encourage you to provide documentation regarding your progress, current status of your treatment when you come back just prior to November 20th. Okay.
Yes, Your Honor.
Okay. Anything further than this morning, Ms. Carr?
No, thank you, Your Honor.
Anything further, Mr. Foland?
No, I nothing other than I just want to talk to my daughter.
Okay, so hopefully the two of you are you're texting each other or communicating by app close?
However Ms. Heflin wants to go about that.
We can FaceTime on her tablet.
Right, but how do you communicate in terms of setting up the FaceTime?
We can text over our phones, but
okay. They text each other in whatever good time, perhaps in the evening, after dinner, before bedtime. The two of you hopefully can agree upon what time is best with your daughter's schedule. It's important that your daughter have contact with her dad. So court would encourage that. All right, with that, the court will adopt a recommendation. The copies will be mailed to everyone, and we'll see everyone on November 20th at 10 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
yeah.
You're welcome.
Have a good day, Your Honor.
Thank you.
The defendant did not appear.
Calling the matter of Raven Heflin versus Jared Foland.
For the record, this matter is before the court for the purpose of reviewing the defendant father's parenting time. This hearing is being conducted via Zoom. President Attorney Leslie Carr, representing the plaintiff, Raven Heflin. Ms. Heflin is present. Is Jared Foland present on audio? It appears not. This matter was scheduled for at 10 o'clock. It's now 10:25. Mr. Foland has not appeared. He's not contacted the court. If the court recalls correctly, Mr. Foland was present on October 8th, 2024, at which time the court continued the matter for review for today at 10 a.m. So Mr. Heflin obviously had notice of that. Mr. Foland, I'm sorry. Hey, Ms. Carr, has your client heard from Mr. Foland all this morning or in the last week or so?
No, the last time she heard from Mr. Foland was on or about November 8th.
Okay. The court is aware he had at one time 3 outstanding bench warrants. I believe the front of the court bench warrant has been taken care of. He was arrested and then he did post, I believe, a cash bond, but I don't know if there's still outstanding bench warrants on a new operating while intoxicated and a probation violation, or do you know if those have been cleared up?
Those bench warrants have been cleared up. He has court dates set in all 3 of those cases, 2 probation violations and a new operating while intoxicated. Those are all set for December 9th in First District Court. He reported to Ms. Heflin that he was placed on some type of tether device, but she hasn't heard from him since November 8th, so we don't know what's happening.
Ms. Heflin, has Mr. Foland had any video contact with your son?
He has had 2 phone calls with Snow since the last hearing, and the last one was November 8th, and I have not heard a word from him since then. And the phone calls only last about 6 minutes, 7 minutes at that, and then he has to go.
Right. All right. Thank you. Of course, so Ms. Carr provided the fine recommendation. Yes, the court did want the video calls to continue, so that will continue. Thank you, Ms. Brower, for addressing that. So the court will order suspending, noting that father's screen time will continue to be suspended, but he shall video calls with non-child supervised by the plaintiff at days, times to be agreed upon by the parties. So obviously, Ms. Heflin, it's important that your child have a relationship with dad, and so to the extent you can encourage that, allow that to happen, make it happen with Mr. Foland, that would behoove and benefit your child.
Yeah, as far as that, I would love him to have a relationship with Snow. I just wish him to be of sound mind and make good choices to be a good role model for her.
Certainly. So hopefully the video contact will continue. Maybe the court will note that he's failed to appear today and go adopt recommendation. Anything further, Ms. Carr?
No, thank you.
Okay, thank you. No future review dates at this time until, I guess, Ms. Foland have to petition the court. All right, thank you, Ms. Barley. The court will adopt recommendation. Now we'll conclude this here and everyone can zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
For the record, this matter is before the court on the plaintiff's motion to modify parenting time. This hearing is being conducted via Zoom. President is Attorney Maria Zagorski, representing the plaintiff mother, Chelsea Pierce. Ms. Pierce is present. In addition, Attorney James Houston is present, representing defendant father Isaiah Smith, and Mr. Smith is present. Good morning, everyone.
Good morning, Judge.
Morning, Your Honor.
Parties have conferred this morning with Mr. Pratt from the front of the court, who has provided the court the following recommendation that both parties shall take parenting classes. Obviously, Ms. LaPretta is reading this court's mind because that's exactly what I made a note of to order when I reviewed the pleadings. Presume the front of the court can provide information regarding the agency that provides the appropriate parenting class. Further, it's recommended that father shall supervise parenting time at family counseling shelter services. Circuit court shall pay for the intakes. Father shall pay for the visits. The party shall appear before this court to review parenting time and enter their issues on November 27th at 8:30 a.m. That is a recommendation. Mr. Houston, is this recommendation good with your client this morning?
It is not, Your Honor.
Okay. Essentially, this suspends his parenting time. At least in-person parent, well, that's requires supervised parenting time. Ms. Sikorsky, the allegations are that he has made derogatory comments to plaintiff mother in the presence of disparages the mother in the presence of the child, and also inappropriate conduct in the presence of the child at karate lessons. Is that enough to require therapeutic parenting time?
Judge, I believe that it is. I think that dad needs some help with becoming a better parent. I do have the child's teacher in my waiting area, Mrs. Roth, who came here of her own accord today because she's so concerned about this child. He soils himself when he has to see his dad. He's angry. He's frustrated. She sees a complete behavioral change, and she would testify to that. And I did not file this, as I've pleaded, he exercises his parenting time intermittently. That's not the issue. The issue is that he needs to be a better parent for his son. My client has tried to facilitate his time by working with him on his days off. But at this point, we believe that Mr. Smith needs the assistance. It's not a function of course, my client will take parenting classes. She has no objection to that. But this is more Mr. Smith's ability to be a better dad.
Did the parties listen to the teacher when you met with Ms. LaPrade this morning?
No.
Okay, why not? Why not? Maybe Mr. Smith needs to hear from the teacher.
I can go get her if you want to put us in a breakout room. She's going to help.
Mr. Houston, any objection? Maybe dad needs to hear from the teacher if there's issues.
I would have no objection to going into a breakout room and so that the teacher can tell us what, talk to my client. That's fine.
Okay. And the last question, Ms. Gorsuch, I know there's a specific parenting time schedule for dad every Tuesday and Thursday, 5 to 8:30, every Sunday, 10 to 2:30, but that's not been the past practice. What has been the past practice? It's alleged, I think, Monday and Tuesdays after karate.
Well, dad has Monday and Tuesday off, and so that's why it's been Monday and Tuesday. Most recently, he's been exercising parenting times on Tuesdays from 3:15 to 5:30, because then the child does have karate, and I appreciate that dad understands how important that is to this child's self-esteem.
Okay, well, no, court's question, why can't we continue at least that parenting time, 3:15 to 5:30 on Tuesdays? I don't know if there's a waiting list at Family Counseling Services. The court's concerned about there being a lag in the time when dad can have physical contact with this child.
It's my understanding, we did talk about that, Judge. It's my understanding that there is no waiting list for supervised parenting time. There is for therapeutic. And, the Tuesdays can continue from 3:15 to 5:30, but again, we just want them to get some help.
Okay. So you're agreeable then dad's parenting time can continue on Tuesdays, 3:15 to 5:30?
Sure. He's been doing that for the last 4 Tuesdays. I would ask that he not swear around the child, that he not belittle him, that he not criticize karate, that he not encourage him to fight.
Well, I would hope Mr. Smith heard that, and yes, those are inappropriate if he's making those encouragements for the minor child. It's certainly not healthy for the child. What about Mondays? Right now, essentially, dad has off for Tuesday, so that is a clear time for him. Is that correct, Mr. Houston? 3:15 to 5:30?
That's correct, Your Honor.
And what's the past practice? Mr. Houston's picking up the child at 3:15?
That's correct,
mom,
yes.
Is that correct? Takes him to karate, then takes him back to mom at 5:30?
No, he's not allowed to be at the karate facility. The owner won't allow him because of his conduct. So he brings him back so that my client can get him to karate.
Oh, I'm sorry. So the karate facility will not allow dad to be present. Is that correct?
That's correct. The owner doesn't want him there because of the way he's acted.
no karate on Tuesday afternoons.
Right.
All right. All right, of course, inclined to modify the recommendation that is for any time Tuesdays, 3:15 to 5:30. Can review this. Mr. Houston, again, do you want, perhaps it's appropriate if we have the teacher here that the dad can hear from the teacher if in fact Avery is having issues at school.
Yeah, I would have no objection to the teacher coming in and telling Mr. Smith what she has to say.
Mr. Brad, do you see any downside to the teacher making known to dad some of the issues that his child is suffering at school?
Your Honor, I don't see a problem with it as long as dad takes it as constructive and not as a tax.
Your Honor, if I may, I think maybe perhaps this might be best served not on the record under direct and cross-examination, but perhaps more informally in a breakout room. I think that might be more constructive and less confrontational and perhaps more healthy or helpful for the parties. That's my opinion.
Yeah, I don't need to call her as a witness, Judge, but I would love for Mr. Smith to hear what she has to say so that he can do what's best for his child.
Maybe we can just have the teacher provide some insight in terms of what Avery's experiencing at school, and the parties can simply listen, not have to respond or argue, just simply listen. Mr. Smith, you want to just simply listen to the teacher?
Yeah, I'm willing to listen to the teacher.
Okay. Well, it's important that you hear these things. So, all right, I'm putting you in a breakout room then.
Okay, I'll go grab her. I'll be right back.
Teacher. Right back in the record, Mr. Gorski, Mr. Houston, both the parties were able to hear from the teacher, Avery's teacher this morning. Is that correct?
Yes.
Correct, Your Honor.
Okay. And hopefully it was enlightening for both parents. Again, with respect to dad's parenting time, obviously we'll review parenting time November 27th at 8:30 via Zoom. Mr. Houston and your client is already willing and able to exercise parenting time on every Tuesday from 3:15 to 5:30. Is that correct?
That's correct, Your Honor.
Okay. What about the Mondays, Mr. Gorski?
He hasn't come on Monday. I don't know if that.
I can do Mondays. Like I said, I don't get any answer, and it's not on my schedule through court, so I don't just pop up. So, okay. But I can do Mondays if they're willing to let me do Mondays.
Okay, so maybe we should talk about then just simply modified parenting time schedule rather than have to do their supervised parenting time. It's an expense to the court, expense to the parties, expense at least to dad. Mr. Gorski, what's your client's feeling about Mondays? I'm not sure what time on Mondays Mr. Houston is suggesting. What about this 3:15 to 5:30? Is that good for Avery to keep it consistent, the times?
I think Mr. Smith, I think that would work well with Mr. Smith. Mr. Smith, 3:15 to 5:30 on Mondays as well. Is that something you'd be able to do?
Yeah. If he has karate, yeah. But if no karate, I would like a little longer or whatever. But I mean, if well, yeah, Mondays.
Does he have karate on Mondays?
No, he doesn't.
Okay. What time does he get out of school? 3:15?
He's home by 3:15.
He's home by 3:15.
Okay. Does it make more sense to minimize contact between the parents that he picks them up from school?
The school has indicated that it does not want that to happen.
Okay. All right. So Mrs. Gorski and Ms. Pierce have an objection to dad having parenting time on Mondays and Tuesdays, 3:15 to 5:30, each of those 2 days?
Not supervised.
It would not be supervised.
Then I object.
She really would.
Mr. Smith's home? You can take him to a park if the weather's nice?
I usually just take him to whatever he wants to do. Like today, we're going to the mall, to the Funland, he calls it. So I usually just take him to whatever he wants to do. If he wants to play his game, I have a PlayStation here. So if he decides he wants to play the game, I usually just let him play his game for 2 hours. And I take him home. So it's pretty much whatever he wants to do. I don't have a game plan for him.
Well, I think it'd be more interactive rather than just have them sit play a game on a computer. You want to spend time with the son and father.
So we go to like Funland at the mall, or we go around, we ride our bikes or ride our scooters, but it's getting cold out. But we also can play our games together is what I'm saying. We like I have a game, he has a game, so we play together.
Okay. You know? Understood. That's good. It's something you pay together rather than just have him sit in a room by himself playing a computer game.
Yeah, no, he don't sit by himself in a room, no.
Mr. Gorski, any objection to dad having parenting time on Mondays and Tuesdays, 3:15 to 5:30?
No, not necessarily. But again, the no swearing, the taking Mrs. Roth's suggestions to heart, staying positive, not encouraging fighting. What we want to do is we want to get Avery to a point where he doesn't soil himself when he finds out he's going to see his dad, right? That's not healthy, and it's having a very negative effect on him at school.
Is Avery involved in any counseling?
Yes, he is. He goes to counseling on Wednesdays.
All right, so that will continue.
Yes.
All right, Mr. Practical, modify the recommendation rather than supervised parenting time for dad. Dad will have parenting time on Mondays and Tuesdays, 3:15 to 5:30 p.m. And dad will do the pickup and drop offs. Is that been the practice?
Yes.
Yes.
Okay. And again, both parties shall enroll in a parenting class. Mr. Pratt, is there a particular class that your office recommends?
Your Honor, they do parenting classes at Family Counseling and Shelter. They also do them at the community center on the east side of Monroe, the Arthur Leslow Center. And I'm not sure if Mr. Smith is in Monroe, but those are the ones that we are aware of.
Are those in person or are they Zoom?
The ones in Monroe are in person.
Your Honor, Mr. Smith, he is of limited means, and gas to and from these classes is a consideration for him, costs for those kinds of things. I'm wondering if it would be possible for either the attorneys, whatever, to find a Zoom, a class that the parties could take on Zoom to minimize that expense for the parties.
Judge, I have to ask that it be in person. It's just
in that county where he may be able to have in-person parenting classes.
Okay.
He's in Luna Pier.
I can make it cool. I just say I'm not like in Monroe County. I'm not like in the township. I live 20 minutes away. So
he's in Luna Pier.
All right, so Mr. Pratt, could indicate both parties shall take in-person parenting classes, make it real clear.
Yes, sir.
Mr. Smith, obviously, one is Family County Shelter Services. I don't know if you're going to write down their phone number. It's 241-0180. You can make inquiry of when those classes are.
Okay.
And the other one is at the Arthur Leslow Community Center. Is that correct?
Correct.
What agency is that, through MCOP?
It probably is, Your Honor. I just know that that's where they're located and that's where the sign up is over at the community center.
All right, so Mr. Houston, perhaps you can assist and guide Mr. Smith in that regard.
Certainly.
To complete those classes. So again, both parties shall take in-person parenting classes. Dad's parenting time is modified to Mondays and Tuesdays from 3:15 p.m. to 5:30 p.m. Dad will pick up and drop off. And the court will review parenting time on November 27th at 8:30 via Zoom.
Thank you, Judge.
Your Honor, if I may, on that date, the 27th, it's the date before Thanksgiving. I'm going to be traveling on that day. I'm wondering if it'd be possible for the court to instead have that review date a week prior on the 20th. Alternatively, the parenting time courses we're not talking about supervised parenting time anymore. We're talking about parenting classes for both the parties, which I think run a little bit longer. Like Ms. LaPrade mentioned, a 6-week course. We wouldn't have time for the parties to finish that 6-week course.
Okay, we can look in December then, the first week of December. How about, let's look at our calendars for December 3rd and 4th. How about the morning of December 4th? That's a Wednesday.
That would work for me, Your Honor.
That's fine, Judge.
Any court before 8:30?
8:30 is fine.
Does that work for the parents, Mr. Smith, Ms.
Yep.
Pierce?
Yep.
8:30 work in the morning work via Zoom.
So I come
here.
Wednesday, December 4th.
Yeah, that's fine.
All right. So we'll review parenting time December 4th, 8:30 via Zoom.
Great.
Okay, thank you, Your Honor.
Anything further this morning, Mr. Gorski or Mr. Houston?
No.
Nothing from my end, Your Honor.
Okay, so Mr. Smith, hopefully you got some insight in terms of some of the issues that Avery is experiencing, and please be supportive and constructive and gentle with them.
Yes, sir.
Hopefully you'll benefit from the parenting class. So with that, we'll see everyone then on December 4th at 8:30 a.m. The petition of Erica Brody to modify a personal protection order entered by this court on April 15th, 2024. This hearing is being conducted via Zoom. Present is Attorney Billy Jeffers, representing the respondent, Leland Mays. Good afternoon, Mr. Jeffers.
Good afternoon, Judge.
And Mr. Mays, Leland Mays is seated next to you, is that correct?
That's correct, Judge.
Right. This matter was scheduled for at 1:15. It's now 1:30. Ms. Brody has not appeared. She's not contacted the court. There's no proof of service in the court file. Was Mr. May served with a copy of this petition notice of hearing, Mr. Jeffers?
Judge, my client received this motion to modify, I believe it was Sunday afternoon, Sunday evening, when his son delivered his mail to the house where he's been living since April. And his son said, I believe there's a court paper in there. You might want to look at it. And that was how he received the packet that I have in front of me.
Very well. The court would note the PPO does expire April 12th of 2025. And the alleged allegations of the petitioner seem to consist of hearsay.
I agree, Judge. I'll tell you that so Miss Rurka was handling Mr. Mays's criminal matter, and she had referred him to me to help him with a landlord-tenant matter. And she specifically asked that we wait till the criminal matter was over before moving forward with the landlord-tenant issue. We've done that, and that's what I believe that this is in response to. I'll also let the court know that Mr. Mays is trying to get his feet back under him. He does have an electric balance that's owed, and he's been told by the energy company that the lights may be shut off by Monday if he doesn't pay that $250 approximately. He's tried to contact his children because 2 of his children and Miss Brody live at this house, and none of them are contributing to the bills. So I wouldn't be surprised if she files another motion if he's unable to get that bill paid.
The court's aware the parties have a child in common, but they were married at one time. Is that correct?
No, Judge, they've never been married. At most, they did consider marriage, and there is an affidavit for a license to marry that was in that packet, but they never followed through and completed the ceremony and officially were married.
Okay, but there's a support action pending. Did they own real estate together? What's the history on this eviction action?
They did not own the real estate together. Mr. Mays purchased the house via land contract from his father. The land contract was from June of 2010. And since then, he has been the only owner on the house. So we've begun the eviction process. We have a hearing in front of Judge Brown on the 14th to move that forward.
Okay, so Miss Brody has no interest in that real estate, correct?
None whatsoever. She's been living there without contributing anything towards the bills.
Very well, it's now about 1:32 p.m. Miss Brody is not appeared, not contacted the court. Court will accordingly enter an order denying her motion to modify this personal protection order. Of course, that doesn't prevent her from filing another motion next week. The court wishes it could restrict her from filing other motions when she doesn't appear, but I don't think the court can do that. Mr. Mays and Mr. Jeffers, in any event, the court has entered an order denying the motion, and hopefully they'll put an end to it.
Thank you, Judge.
Thank you, Mr. Jeffers. Have a good afternoon.
Thank you. You too.
Calling the matter, Sarah Bajara versus Marcus Daniel.
The record, this matter is before the court on the plaintiff mother's objection to a referee recommended judgment of support. It is being conducted via Zoom. Are you Sarah Bajaro?
Yes.
Right, good morning. And sir, you are Marcus Daniel, is that correct?
Yes.
Okay. The judgment of support provided for joint legal custody of your minor child physical to the plaintiff mother and reasonable level of parenting time to the defendant father. 2 of you have conferred this morning with Ms. Brower from the front of the court, who's provided the court the following recommendation. The recommendation is that plaintiff mother should have sole physical as well as legal custody, and father should have specific parenting time rather than reasonable liberal. If there's that avoids any argument, father should have specific parenting time every other weekend, Saturdays and Sundays from 10 a.m. to 1 p.m. commencing October 19th, 2024, which is a week from a Saturday. Parenting time shall take place at the plaintiff mother's home or an agreed upon location, and father shall have such additional parenting time as the parties can agree upon. Child support, effective November 1st, 2024, shall be a total amount of $710 per month paid by defendant father. Uninsured medical expenses shall be shared by the parties as follows: plaintiff mother paying 10%, defendant father paying 90% of uninsured medical expenses for the non-child. That is a recommendation. Ms. Bajal, do you understand the recommendation?
Yes.
Right. Are you agreeable with the recommendation?
Yes, sole physical custody with, starting
Today,
10 to 1 on Saturdays and Sundays.
that's
And
parenting
I pay
time.
10%, and I pay 10% of medical costs.
Uninsured medical expenses.
Okay, yes.
All right, Mr. Yancha, do you understand the recommendation?
Yes.
Do you, are you agreeable with the recommendation?
Yes.
Right, can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Ms. Bajau, can you state your name and current mailing address for the record, please?
Sarah Espinosa Behaviour.
Ms. Bajau, do you believe that this recommendation, if adopted by the court, will be in the best interest of your minor child?
Yes.
Right, do you have any other questions for the court?
No.
Mr. Yancha, can you please state your name and mailing address, please?
Marcus Wayne Antioch.
Thank you. Mr. Yancha, do you believe this recommendation is in the best interest, if adopted by the court, will be in the best interest of your minor child, Harlan?
Yes.
Do you have any questions for the court?
No.
Okay, the two of you talked about transportation. Would dad pick up or mommy going to drop off the minor child? I'm sorry, it's going to occur at your home. That's right. I apologize. So current place home, but if you agree to meet at a park, then so be it. But if you do not agree, the parent time will take place at Ms. Bajaro's home.
Yes.
We'll start a week from Saturday, Saturdays and Sundays, 10 a.m. to 1 p.m. As well as such other times parties can agree. Obviously, this child needs an active dad and mom in their life. So both you need to encourage a strong relationship with the minor child and father. All right, the court finds agreement between the parents to be in the best interest of the minor child. The court will only adopt the agreement, enter the order. You both can mail the copy of this. And please communicate with each other for the best interest of your child. There's enough challenges in life, don't make things more difficult, okay?
Yes.
Right, that will conclude, sir. You can both zoom out. Thank you, Ms. Brower.
You're
I have one
welcome.
question.
I'm sorry?
I have one question. How does the
All
child
right,
support, does the child support come right out of my check? Do they have all the information that they need to, is it going to come out automatically?
We'll make sure the front of the court has that information. And then sometimes it takes 6 or 8 weeks. So until you see it come out of your paycheck, you should pay it directly to the Monroe County front of the court.
Okay.
And if you're changing employers that they can't keep up with that, you need to keep them informed. It's much easier if it comes out of your paycheck if you have a long-term employer. But if you working out of a local and you have different employers every couple of months, you need to keep the front of the court informed. You need to pay that directly if it's not coming out of your paycheck.
Okay.
Ms. Bard, do you know, does your office have current employment information regarding Mr. Antar? Does he need to come in and complete paperwork?
I'm going to call him.
I believe we have his current information when we ran the child support guidelines.
Okay. All right, now, obviously, you both have a caseworker that's assigned to this case. So if you have any concerns, questions, issues, you always ask for your caseworker.
What's the caseworker? I don't know. I didn't even know I had a caseworker.
I didn't either.
You should have received a business card with a letter when the case was first established. Your caseworker is Catherine Scott.
That's first I heard of it. I didn't get a letter either.
Kathleen Scott?
Catherine Scott. All of her contact information is on our website at monroefoc.org.
monroefoc.org. Okay.
So Kathy Scott is your caseworker. If you have any questions, you talk with Kathy Scott.
Okay.
So if I don't see a change in my check, I need to go directly to the courthouse and pay them there, right?
Or you can pay it online.
Okay. Do I get a card in the mail or do I go up to the courthouse? How do I receive the child support?
It'll be mailed to you.
You will receive a card in the mail.
Okay.
Keep the front of the court informed of your address. If you move, you need to keep the front of the court informed of any change of address in the future.
Yes.
This case will be open until such time as your child attains the age of 18.
Okay.
Okay, if that answers all your questions, that will conclude the hearing. You can all both zoom out and have a good rest of the day.
Thank you, sir.
Thank you, Ms. Brower.
You're welcome, Judge.
For the record, this matter is before the court on the defendant's father's motion for to show cause for alleged violation of the parties' joint legal custody order, as well as the defendant's motion for therapeutic parenting time for the minor child, one of the minor child, I believe Harrison. In any event, this hearing is being conducted via Zoom. Present is Attorney Alexis Stang, representing the defendant father, James Roy. Mr. Roy is present with Ms. Stang. In addition, the plaintiff mother, Kelly Roy, is present. Good morning, everyone.
Good morning, Your Honor.
The court has reviewed and read all the pleadings, responses. The parties have met with Mr. Walker from the front of the court this morning, who has provided the court the following recommendation. If adopted, will become an order of the court. The recommendation is that parties agree that the minor child Harrison shall start counseling. Defendant father shall contact sound mind behavioral wellness, transformational choices, family counseling shelter services, as well as creative counseling in South County. That's Mark Haskins, to get intake or to put Harrison on a waiting list. The minor child shall start counseling with whatever counselor is first available. And with that, the motion for it to show cause shall be dismissed. The minor child Raleigh shall be evaluated by a counselor regarding therapeutic visitation with defendant father. Defendant father shall contact the same list of counseling services above for the minor child Raleigh, and she shall be evaluated by the first counselor that is available. So that is a recommendation. Ms. Stang, is this recommendation agree with your client this morning?
It is, Your Honor. Thank you.
Okay. The court did receive correspondence, so no for the record. I'm going to take a report from Pure Psychiatry of Michigan, Jennifer Johnson, who has been working with the minor child Riley, but apparently Ms. Johnson is now responding to Mr. Roy's communication. Is that correct, Ms. Stang?
Yes, that is correct, Your Honor.
Have you attempted to reach out to Ms. Johnson?
I have, and I actually left a message for her office explaining why I was contacting this situation. I was told that somebody would contact my client back, and neither of us have received any response.
And I do note this was a letter dated August 30th, 2024, from Ms. Johnson regarding the minor child Riley, indicating that when Riley has reached a level of stability that she's comfortable with interacting with father, then Riley's father will be invited to attend therapy sessions to reveal their relationship. That was 6 weeks ago. Now, I don't know, how often does Riley see Ms. Johnson?
She's there twice a month.
Twice a month? Well, Mr. Roy, obviously, Ms. Johnson should at least be responding, saying, okay, we're still not there, at least respond. I mean, it's obviously frustrating when a professional therapist will not respond to the other party. Just simply answer the question, is there any progress? And the court has received no updated letters from Ms. Johnson. All right, Ms. Roy, do you understand the recommendation this morning?
Yes.
Do you have any objection to the court adopting the recommendation?
No, I do not.
All right. Obviously, it's always difficult to change horses midstream. If Riley has a good relationship with this Jennifer Johnson, to change that. But obviously, if Ms. Johnson is not responding to legitimate requests from father, and then I guess we might make that change. And same with, has Colton started yet with this agency, Ms. Roy?
This is would be Harrison. He has not started with an agency.
Harrison, I'm sorry. Harrison, yeah, my notes to reflect Harrison.
Yeah, he has not started with an agency. He just sees the school counselor. But I do believe he has some issues that need some further attention.
Well, presumably Mr. Roy agrees that with that, he just simply, let's get him in as soon as possible. He had concerns about this agency. And again, Ms. Johnson is not your best friend's sister. You just have your friend's sister owns the clinic, but it's not Ms. Johnson, the actual therapist. Is that correct?
So Miss Johnson is with Pure Psychiatry. I had made Harrison an appointment with Minnie Mitten in Monroe here. And I just let Mr. Roy know that our friend Carson that's the owner of the practice, but not the actual psychiatrist. Just relating it that the practice came highly recommended. And so that's where I had initially made the appointment, but he is requesting a change of psychiatric evaluation. So.
Well, Minnie Mitten does have good reputation, but obviously the recommendation references specific agencies. So Mr. Roy, with this assistant, Ms. Stang, will reach out to Sound Mind Behavioral Wellness, Transformational Choices, Family Counseling Services, and Creative Counseling to see who can see Harrison as soon as possible. And then who's ever immediately available, Harrison will start counseling with that counselor.
Yes.
Same with Riley. Those agencies will be contacted to make an appointment with Riley. So both children will be seen by the same counselor, correct?
Correct.
Okay. Probably makes sense. So the counselor gets a good idea what's going on in the family dynamics. And Mr. Roy, it's critical that you keep Miss Roy informed.
Yeah.
And obviously, with respect to parenting time, whoever has the children those days needs to make sure that you get the children to those counseling sessions.
Absolutely.
All right, Miss Roy, do you have any other questions?
No, sir.
Anything further, Miss Stang?
No, thank you, Your Honor.
All right, the court will adopt the recommendation. Everyone will know the copy of this. So make some contacts today, Mr. Roy, and do keep Miss Roy informed of your efforts. It's critical. You have joint legal. Both you need to keep each other informed of those decisions. All right, that will conclude. Somebody can both zoom out. Have a good rest of the day.
Thank you, Your Honor.
For the record, this matter is before the court on the defendant mother's objection to a referee recommended order modifying parenting time. This hearing is being conducted via Zoom and we have both parties present. Ma'am, are you Haley Morales?
Yes, sir.
All right, good morning, sir. You are William Morales.
Yes, sir.
So the two of you cannot agree upon parenting time. Is that correct?
That's correct, Your Honor.
It's very sad for the children. You're asking a total stranger to decide what's best for the children, regardless of your schedules. The two of you, as a parents of three children, should be able to sit down and say, okay, this is my work schedule. This is what we think is best for the children. But you're asking a stranger to do that, namely the court.
I agree completely, sir. With the circumstances of the points that I brought up, I really just wanted the adjustment due to the safety of my children. I just want to ensure that they're safe and that they have proper stability in their life.
And Ms. Morales, you want to spend money and hire an attorney, is that correct?
Yes, I have Maria Zagorski still.
Well, but you have to pay her. You need to pay a retainer for her.
Yes, sir, I do.
Okay. So you're asking for an adjournment just so that Ms. Zagorski can, so you can retain Ms. Zagorski, is that correct?
Yes, Your Honor.
All right. All right. The court has received a proposed order that the matter be adjourned at the request of defendant mother to October 30th at 9:30 via Zoom. Will that day work with both your schedules?
Yes, Your Honor.
Okay. Now, Ms. Morales, the court's going to only adjourn this once. So you need to contact Ms. Gorski today, because if she's not available, I mean, she's got to make herself available or you got to find a different attorney.
Yes, Your Honor. And I have contacted her this morning already.
Okay. And she's available that date and time?
I didn't know the date and time until just now, but she's supposed to be calling me back. She's in other hearings this morning.
Okay. All right. Mr. Morales, this work with your schedule, October 30th at 9:30?
Yes, sir. I'll make it work no matter what. But one thing I did state in the last breakout room is I personally don't believe that like Miss Haley should get another adjournment because she didn't even show up to the first basically hearing with the referee, if you will. She's had more than enough time to get this situated, and still it's just lackadaisical and it's just put on the back burner. And I just want things set and handled, and I want to have a proper schedule for my children.
Well, you have parenting time right now. We're just modifying the parenting time.
Correct. I just have a little bit of parenting time, as you will. Most of my parenting time is driving the children around and basically getting them to their obligations that they have, such as extracurricular activities, school, etc. I'm basically the parent that is driving and doing everything. I'd like some time with my children.
Understandable. But notwithstanding the fact that she failed to appear for the referee hearing, we're going to give her one more chance. So this matter is adjourned to October 30th at 9:30, and the matters will be addressed at that time. And this court will make a decision. So the court would encourage you as parents, talk.
I was
Just
hoping we
think
could
about it. Just think about you're entrusting your children to a stranger to make how to raise them. So with that, the court will be able to mail the copy of this order October 30th at 9:30. We'll see you then. Now,
Thank you.
you can both zoom out.
Thank you, Your Honor.
Thank you.
Welcome. Yes, Sam.
Hi, Mayor William Morales versus Morales.
For the record, this matter is before the court on the objections to a referee recommended order filed by the defendant, Haley Morales. The matter was adjourned so that Ms. Morales could consult an attorney. In any event, this hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing Haley Morales. Ms. Morales appears to be present with Ms. Zagorski. In addition, William Morales is also present. Good morning, everyone.
Morning, Judge.
Parties have conferred this morning with Ms. Brower from the front of the court, who has provided the court with the following recommendation: that the referee recommend order be rescinded and canceled. The parties shall use AppPost for all communication. All appointments for the children shall be added to AppPost at the time the appointment is scheduled. Neither party shall discuss this case with the minor child, and no disparaging remarks by either parent toward the other parent, particularly in the presence of the minor child. That is a recommendation. Ms. Zagorski, is this recommendation good with your client this morning?
It is. Thank you, Judge.
Okay, Mr. Morales, good morning. Do you understand the recommendation?
I understand, but I don't agree with it.
Okay. Reggie, you filed a motion to modify parenting time because your work hours changed, correct?
Exactly.
Okay.
I changed my complete lifestyle. I was working at a dispensary all the time, and now I literally work at GM, where I work from 7 a.m. and get off at 3:30.
Okay, so what is your current work schedule?
My current work schedule is Monday through Friday, 7 a.m. till 3:30. And yet I have asked for more time, and I keep getting told no. I just want to know why I cannot be a father to my kids when I want to be. I need more time with them. They need more time with their dad. It's being hung over my head for a little bit more money. It's just craziness to me.
All right. Two of the issues that were present in front of the court recommendation is that Brandon Clare shall not be present with the children, mother's boyfriend, Ms. Zagorski. Was that addressed during your discussions this morning with Ms. Brower?
Yes, my client got a PPO. So Mr. Clare is gone. She solved that problem.
Well, the PPO does not prohibit Ms. Morales from inviting him back.
Exactly.
That should be addressed in any order. And obviously, if dad's right now, the current parenting time order seems like it's chopped up. The children are moved back and forth, back and forth. The recommendation seems reasonable that dad shall have the weekends, Friday after school, because he's home, Friday after school, 5 p.m. to Sunday, 7 p.m. What is unreasonable about the federal court recommendation, Ms. Zagorski?
Well, my client also works Monday through Friday, Judge, and Mr. Morales in his motion raises issues that predate the judgment of divorce. The issue that he raises that occurred after the judgment was entered is the Mr. Clare issue. And Mr. Clare, like I said, is the subject of a PPO. My client doesn't want anything to do with Mr. Clare.
Right. Understand. We're going to address that in this order because the PPO does not prevent Ms. Morales from inviting him over for dinner, because there's one day I see these too often. People on PPO, and I'll say, well, we're getting along now. He has apologized and so forth. So we'll address that, Ms. Zagorski, in this order that Brandon Clare shall not be present with the children. But dad's new job occurred prior to the last parenting term, entered.
Yeah, Judge, and listen, I don't have any problem scheduling a mediation so that these parents can talk about the issues. But quite frankly, Mr. Morales has called the sheriff's department. He's called CPS on my client. He calls her a whore in front of the children. They tried the every other weekend over the summer, and Mr. Morales would say, well, I don't want to take this one to that birthday party, so you have to do it and I'll keep these two. He doesn't understand the rules of co-parenting. So if you want us to have a mediation so we can talk about what that looks like and how that works, I am more than willing to do that. But just out of the gate, to say that Mr. Morales should have every other weekend when he, first of all, hasn't carried his burden of proof. And second of all, we've tried it and it's failed. And third, he is absolutely vile to my client on a regular basis. That's not going to work for these kids, and it's not going to work for my client.
All right. So they're all valid points, Ms. Zagorski. Mr. Morales, when did you start this new job?
Yes, sir. I started about 7 months ago at GM.
And just today, Judge, I asked him if we could refer the case to the front of the court for a modification of child support, since he acknowledges that he changed jobs. He didn't notify the court in writing, and he said no. So I have to file a motion. That's what we're dealing with.
I had to file a motion for my parenting time. I'm just trying to be a dad. I had to file that. So understand me there.
Well, Mr. Morales, you are required to keep the front of the court informed of any change of employment. So yes,
I understand that now, sir. I
do
really apologize for not being able to for not doing that. I thought me in the last hearing, if you will, I thought that was me doing that by letting you guys know that I got a new job. I wasn't aware that I had to go deeper and put it in writing. That's my fault.
Okay, so your divorce was entered in May of this year. You were employed by Jim at that time. Why didn't you address parenting time at that time?
I honestly, I didn't know that I had to right away. And I could have sworn when we were in the middle of me like leaving the other job and going into this, like we had a hearing and I said it there too, that I'm starting at GM. I got a new job in line and everything. I thought it was me. Like, I thought that was okay. And that was taken care of on that end. But I understand that now I have to put it in writing. I'm right around the corner from the courthouse. I thought we were in person today. So I came there. So like right after we get off of this call, I'll come right there and give you guys it in writing. No problem.
Because right now your parenting time is every Tuesday afternoon to Wednesday morning. Do you have the children overnight on Tuesday nights?
Yes, sir. I have all right. So my
well
parenting time works Sunday from 12 to 6. Lately we've had football, so that's really like kind of interacted with that. Football gets done around 3:00, but it is the end of the season. It gets done at 3:00, and so I would keep the kids till 6. So that's like a total of 3 hours right there with the extracurricular activity. On Mondays, I would then pick up the kids from school, and then I would take my daughter to gymnastics with all the kids, which would take an hour and a half out of my time with them, and I only keep them until 6. So that's 3 till 6 again. On Tuesday, I do get my overnight with them. I keep them after school, which we did have football practice till about 7:30, which now that's not the problem. Now I get to keep them overnight until the next morning and drop them off at school.
But Mr. Rouse, extracurriculars are important for the children.
100%.
Whether it's gymnastics or whether it's a birthday party, and that's things you as a parent should enjoy with your children.
Exactly.
You should go to the practices and watch your children participate, whether it's football or gymnastics. So don't say, I'm losing my parenting time by taking them to these activities.
I get that.
You're looking
I
at
get
it the
that.
wrong way, Mr. Morales.
I'm sorry. And I didn't mean it like I'm losing my time with them. I'm just saying like I'm not getting a lot of that one-on-one time with my children, like in our home front, if you will. Like I feel like a lot of me is just doing the run around because that's
part of being a parent, Mr. Morales.
And I'm okay with that. I'm okay with that, sir.
Hold on. You should support those activities. Mr. Morales, did we lose you? Okay, it appears we lost him. All right, Mr. Morales, can you hear the court?
Yes, I can. I'm so sorry about that. My phone died.
That's all right. We waited to reconnect.
I appreciate you guys. Sorry about that.
So those extracurricular activities are important, Mr. Morales, and you should, for example, it's one-on-one time with your daughter if she's got gymnastics to take her there and ask her how things are going. And I don't know if they allow parents to observe, but those are important things as being a parent. Very well, Mrs. Zagorski's suggestion makes a lot of sense, Mr. Morales, that the two of you mediate. Now, parenting time, but also child support. Child support needs to be addressed and modified. In the court, you're both here. The court does not want Haley to have to incur a filing fee, and both you have to come back to court on the issue of child support. Are you willing to meet with Haley and Mr. Zagorski to discuss parenting time modification as well as child support modification?
I'm willing to.
All right, Ms. Barr, on the recommendation, the court will not rescind the referee order at this time. I think there's some merit. The recommendation, of course, is every weekend. Mom should have some weekends, Mr. Morales. So maybe you agree upon certain weekends. I mean, maybe the first, third, and fourth, or the first, second, fourth weekend of the month. So the children have some weekends with mom because it's in terms of school year. Maybe you need to have a different schedule for summertime, where you have more time with children during the summertime. But right now, your parenting time schedule seems like it's chopped up a lot. Children go back and forth. They should spend a little more time with dad. The court would agree, but we will add to this recommendation is that the Brandon and Claire shall not be present during mom's parenting time, which sounds like it's not going to be an issue. So we'll add that to this recommendation. Again, in the interim, all communication should be by app close. Load that app on your phone, Mr. Morales. If you haven't planned it for the children, you need to put that in app close. Same with mom. And the children should not be involved in discussions. This is between the two of you as parents. You should not be discussing parenting time or these issues with your children. And don't make any disparaging remarks. Ms. Barr, do you have your availability as to mediation with these parties? Will you put that right in the same order?
Yes, Your Honor.
And the court can simply, after the mediation, address these objections. So at this time, the court's not going to rescind the referee recommended order. We're going to keep everything on the table, Mr. Morales.
Thank you.
Work schedule. You're home at, again, I obviously don't want to interfere with work schedules. Ms. Morales, I'm not sure what her work schedule is. Ms. Gorski, try to work this around everyone's schedule. And maybe at work, you can always, if you have breaks, Mr. Morales, you can step out and you can go into a break room or your vehicle. Plan on a good hour to discuss these things. And there's no reason why you and Mr. Morales cannot talk about these things between the two of you. Two of you know what's best for your respective work schedules and that of the children, their activities.
You're absolutely right.
Encourage that.
You're absolutely right.
There's enough challenges in life. Don't make it more difficult. And obviously, when there's stress and anxiety, the children sense that. They don't need that. Ms. Brower, do you have a mediation availability in terms of the near future?
I have availability on November 18th in the afternoon or November 21st.
Anything nothing in the mornings?
I have the 21st in the morning.
Okay, the court prefer morning. Ms. Zagorski, that's a Thursday morning. Your schedule and Ms. Morales' schedule?
That is my birthday, Judge, and
Oh.
my paralegal is insisting that I.
Okay, well, I gotta put that on my calendar because we ran into that before, so we don't want to interfere with your.
I can do the
21st of November.
22nd, if the 22nd is available in the morning.
I can do the 22nd.
Wonderful. What time, Ms. Brower?
But I typically start at 8:30.
Okay, would that work, Mr. Morales, 8:30?
Yes, sir.
So Friday,
Yep.
November 22nd.
Perfect.
Will that work for Ms. Morales?
It does,
Yes,
Judge.
sir.
All right, so we'll put in this order, the parties shall mediate the issues of parenting time and child support. With Ms. Brower, November 22nd, Friday, 8:30 a.m. Thank you, Ms. Brower, for your availability. That'll be by Zoom. Perhaps you can put in the order your Zoom ID number, Ms. Brower,
Yes, Your Honor.
please. Thank you. And the parties can Zoom into the court after the mediation. And if you don't have an agreement, the court will make the decision. But the court would encourage the two of you, if you can communicate as rational adults, the two of you to communicate in terms of what makes the most sense. Anything further, Ms. Zagorski, this morning?
No, thank you, Judge. Appreciate
You're welcome. Thank you. Mr. Morales, anything further? Do you have any questions?
I don't, but am I able to bring you this information that I have in regards to this case? Like I have like a file of some information for you, and then I was going to give it to Ms. Zagorski too.
Obviously, you need to provide this, Ms. Zagorski. What information are you talking about?
It's a Child Protective Service investigation report and follow-up. It dates to. Yeah, let me check the date on the back of it. It is.
Well, you can provide that to the front of the court, Ms. Zagorski.
Yeah, 9/13/2024. Yeah, I was just asking if I should just run this up to you real quick, like, because I'm right around the corner.
No, because we're not going to address anything. There's no motion before the court to terminate or modify mom's parenting time. So who made the complaint?
He did.
I did.
What's the nature of your complaint, Mr. Morales? Are the children in danger? Is mom abusing the children?
It wasn't quite abuse. It was exactly the danger that the children were basically in, if you will, with being around the violence all the time.
Okay, that's, you talk about this Brandon Claire?
Exactly.
Okay, well, we've addressed that. Ms. Morales indicates that there's a PPO in place that prevents Mr. Claire from having contact with her, and the court's putting in this order today that Brandon Claire should not be present during mom's time with the children.
Yeah, and I would invite Mr. Morales to come to mediation, not trying to sabotage mom.
Yeah, so let's keep an open mind. Mr. Morales said, again, obviously, if Protective Service was concerned, they would have taken action by now. They would have taken in and they would contact the court and say, remove these children from mom. The fact that they've not done so indicates that they think it's no longer an issue. If you call them, I guess they probably already closed their file on the matter.
Okay.
So let's move forward. I mean, obviously, when things like that happen, you should always talk with the mother of your children.
I've tried, sir. I've tried.
Former wife and say, I've got concerns about this. The children, I'm concerned about their well-being. And then if she does not take action, then do what you have to do. But again, let's move forward in a positive, open-minded fashion. So no, the court does not need that information, Mr. Morales.
Okay.
If you call CPS, I'm sure they'll tell you it's closed, done.
Okay.
All right, so Mr. Morales, don't forget you have to personally appear on Monday morning regarding your failure to pay a filing fee. If you want to, you're in the course today, you want to pay it today, come up with a receipt, and then you don't need to appear on Monday morning at 8:30.
Okay.
Because that was previously ordered. I'm just letting you know it's not an issue of argument.
I got you.
So if you want to, the court suggests you can pay that today, come up with a receipt, and then your personal appearance Monday morning is not necessary.
Okay.
All right, that will conclude this matter. We'll see everyone then after your mediation with Ms. Brower on November 22nd, 8:30.
Thank you, Judge.
All right, I'm going to zoom out and have a good rest of the day. Thank you, Ms. Brower.
You're welcome, Your Honor. I'll have that new recommendation in your queue in just a moment.
Thank you. Primary issue at mediation was parenting time. Is that correct, Ms. Gorski?
And we did raise the issue of child support. Mr. Morales changed jobs, didn't notify the front of the court back in May.
Okay. Have the parties been able to make any progress on their own resolution this morning?
I don't think so. I don't think that Mr. Morales is on board with our proposal.
Okay. Proposal as to parenting time or child support or both?
Both, sir.
Yeah, Ms. Brower did run child support this morning based on at least one of Mr. Morales's jobs. And my client's current income, Mr. Morales doesn't agree with that either.
Mr. Morales, the child support is pretty much based on the simple math formulas. So if Mr. Brower made a recommendation, where did she make the error in terms of your income?
No, sir, I wasn't stating that there was an error or anything. The main thing on my end is like I was told from another referee, like in the beginning, that they couldn't raise my child support just because I got a better job. That was just one thing.
That's wrong. If as incomes change up or down, support can be modified. If you break a leg and you're off work and you're laid off, yes, you're going to want a petition for a reduction in child support. So it's always subject to modification until these children attain the age of 18. So whoever told you that is incorrect.
Okay. Another thing too is like with seeking more parenting time, I was seeking more overnights, and so I kind of thought that would play in a factor as well.
It plays a small role in the child support calculation, the number of overnights.
Understood.
So, Ms. Zagorski, do we need an evidentiary hearing on this matter?
Apparently, I don't know what the court's going to do. Mr. Morales works midnights, Monday, Tuesday, Wednesday, Thursday overnight. So we tried to work out an agreement here where he could have every other weekend and an evening during the week from school and then bring the kids home because he has to go to work. I don't know exactly what he's looking for given his work schedule.
Was this discussed in mediation?
At length.
That question posed? All right, Mr. Morales, you can represent yourself, can hire an attorney. What do we want to do on this matter?
I'd like to seek representation, please.
Okay. The court has delayed addressing the front of the court referee recommend order. Is that correct?
Correct.
Ms. Brower, there's a de novo hearing, and the court simply continued back to today's date so the parties could mediate. That's the court's recollection. Is that your recollection, Ms. Zagorski?
Yes.
Okay, and the referee recommend order was that father should have parenting time every weekend from Friday after school or 5 p.m. if no school to Sunday 7 p.m.
Correct.
6:30. I think it was the kids go to bed at 7:30. My client thought it was 6:30. However, she didn't receive notice of that hearing and didn't participate.
Okay, so it was Ms. Morales that filed the objection, then, correct?
Yes.
Correct.
And at the same time, Mr. Morales filed the motion to modify parenting time since he has a new job.
Yes, sir.
And again, I don't know what your work hours are, Mr. Morales. The purpose of this was for the two of you to discuss your schedules.
100%.
And the children, what's best for the children. And if the two of you cannot agree, then the court would schedule an evidentiary hearing and take testimony. I mean, it's pretty simple. I mean, Mr. Morales, if you want this court to drive the bus, it can do that. But really, it's very simple. You look at your work schedule, you look at mom's work schedule, you look at the schedules of the children, and decide what's best for the children.
Definitely.
It's a shame if you cannot do that.
Definitely. To be honest, sir, I just feel like I deserve a little bit more time as well. I like with the weekends, but I also could do overnights in the weeks as well. I have a babysitter that I would be able to have for the hours.
We're not just babysitters. We want to know that children spend time with mom and dad. And again, there's more flexibility in the summertime. When children are in school, they need to have a continuity. We're not going to break up in the middle of the week when they have to be on a regular schedule for school, particularly 8 and 7-year-old.
Definitely.
There's more flexibility in the summertime, so you can talk about summertime, there's more flexibility with that because they're not in school.
Yeah, and after our first motion, I kind of expected that coming into the summertime, and it never happened. So that's exactly what kind of led me to file this motion to kind of get more time. Like I'm perfectly fine with every other weekend. I have the weekends off, and I can even get every weekend off if it came to. But like I said, I would just and I don't care if it's an overnight or not. I just want more time in the middle of the week too. It doesn't just have to be one day. I love spending time with these kiddos.
Judge, my client works until 4 o'clock in Dundee, and the oldest child has gymnastics at 4:15. And she asked Mr. Morales if he would please have parenting time on Monday to get his oldest to gymnastics. And his response was, that's now not how he wants to spend his time. He didn't want to be bothered. So that didn't work for him. I don't know what to do with him. He doesn't want to parent. My client has begged him to co-parent. She's asked him for help, and he says, no, it's not convenient to him.
Your Honor, may I speak for myself on that end?
Yes, obviously it's good to the children see that you're interested in their extracurriculars.
Definitely.
So,
I absolutely love going and participating in the gymnastics and doing everything with them. Like, don't get that wrong and don't get it twisted, please. Especially when spending time with my kids. I absolutely love spending time with them. We have a great time together.
So do you want
May I speak? Thank you. So on Mondays, my only regard is I am potentially moving to Toledo, Ohio. That would be in Point Place. With that being said, gymnastics would be 30 to 45 minutes from my destination. And then I would have to loop to Ida and then loop back. My only thing, and I have no problem. Like I said, I will do it and I will help, and I have no problem helping. And Haley already knows that herself. I don't have a problem helping. She may not tell you, but that's the truth. And so with that being said, I have no problem with helping here and there, but I just feel like that being forced onto me every Monday, that's a lot on not just me, it's a lot on the kids too, because I have 3 kids with me in the car. I have little Mia, who's 2 years old. I have Xavier, and then I'll have Peyton as well. Peyton's going to gymnastics, and Xavier and Mia are sitting there waiting in the lobby with me. So the reason I said that, and like I said, there's nothing against being a parent. I absolutely love this stuff. I just wanted kind of more of like a day where I can spend time with them and we could go do things, or we get them home, get their homework done individually type of thing.
So
I
we
have no problem with being a parent though. Please
so
don't put
Judge,
that on
we
my
offered, so we offered Wednesday, and he didn't want that either. I don't know how to fix
I went
it.
with the Wednesday, man. I went with Wednesday. I said I could do Wednesday and Thursday and every other weekend. I'm okay with that. I just don't want to have to be the one that's always doing the driving everywhere. And I already have been through this whole process. So I would just like a little help on that. And especially considering my child support's about to be taken up some, like, I just help me out here. You guys are draining me. Like, and I don't mean that with disrespect. I mean that with all respect. I'm trying to be able to be a parent too, buy clothes, buy shoes, buy them anything they need. It's not just Miss Morales. It's not, and it hasn't been this whole time. So I'm still doing everything I have to do. And even if that requires me picking up a few more hours and working extra hours for them, I do it all.
So Judge, we offered to meet him halfway, which is the Ellis Library on M50. My client's on Albin, just off of Lewis, and Mr. Morales currently lives in Monroe. So we were going to meet at Ellis Reference, which is halfway.
That's cool. I like that.
So,
okay, Ms. Morales, say you're the one obviously choosing to move farther away, so you can't complain about drive time. In any event, I got in front of the court bench warrant. Raymond Hale right now. I got somebody from the jail zooming in. 11:15. Ms. Zagorski can. I'd like you to talk to Ms. Morales a little bit further, and I'll take care of this bench warrant arraignment with the front court attorney. Then I'll be back with you. Somebody put you back in the breakout room. Ms. Morales, sounds like you're not that far off. The reality is, parenting time can be adjusted anytime. Right? So you need to figure out what's best right now. November, December, January of 24 and 25. It can always be said. You can always petition for modification in the future as the children get older. You want to be part of extracurriculars, but if the Mondays are too taxing and you can't watch a gymnastics, you're sticking out in a hallway waiting for the children. I understand. And maybe Wednesdays.
It's not that I have
We'll
a
talk about
problem
more
doing
about
it.
this summertime, more flexibility. But I'm putting you in a breakout room. I'll be back with you.
Thank you.
Perhaps you can provide the court with a recommendation after talk with them when I come back in terms of child support and parenting time.
Yes,
Please.
Your Honor.
Morales versus Haley Morales.
Court apologizes for everything bunched up at the same time. We had a number of cases involved mediation this morning. So we're back on the record in this matter. And the parties are present, as well as Attorney Maria Zagorski. Have the parties been able to make any progress in the last 30 minutes, Ms. Zagorski?
Yes, I believe Ms. Brower has uploaded an agreement to your queue.
Thank you. All right, Mr. Morales, listen to this. The court did receive a recommendation from Ms. Brower, and if the court adopts this order, this recommendation will become an order of the court. The recommendation is that father, you, Mr. Morales, shall parenting time on a 2-week rotation. Week 1 will be Wednesdays and Thursdays from school to 6:30 p.m. Week 2 will be Mondays and Wednesdays from school until 6:30 p.m. and Friday, 4:45 p.m. to Sunday at 6:30 p.m. The exchanges of the children shall take place at the Ellis Library, and both parties shall have the right to record the exchange. I would hope we won't have to do that, but this provides for that. You don't want to put the children in the middle of all this and record everything, but if in fact that's what you agreed to, then fine. Further, it's recommended the father shall ensure the children are fed on his weekdays prior to the exchanges at 6:30. With respect to child support, commencing December 1st, 2024, the plaintiff fellow shall pay child support in the amount of $1,171 for the support maintenance of the minor children. It's based upon 75 overnights for the defendant, 290 overnights for the plaintiff. Uninsured medical expenses shall be shared as follows: 60% paid by the plaintiff father, 40% by the defendant mother. After, of course, the mother pays the first $454 per year. The party shall follow all recommendations of the children's therapist. Neither party should make any disparaging remarks about the other in the presence of children or discuss this case with the children. Finally, all appointments and activities for the children shall be added to the APCLOS for the benefit of both parents. That is recommendation. Ms. Gorski, is this recommendation agreeable with your client this morning?
It is.
Mr. Morales, do you understand the recommendation?
Yes, sir.
Recommendation agreeable with you this morning?
Yes, sir. Also, we had in there that we can't be late. I just want to make
That's
sure.
implied.
Okay, I
It's a
just want to make
courtesy.
sure that was added in there.
Be on time. You both should be on time. Now, if in fact there's an accident or the highway is closed, text the other party just as a courtesy. But yes, both of you should be timely.
Okay.
Children don't want to be sitting in a car unnecessarily. And of course, during your time, you'll make sure the children get to their extracurriculars, correct, Mr. Morales, like whether it's gymnastics or whatever it is.
Yes, sir.
Right. All right. Can you both please raise your right hand to be sworn? Do you both solemnly swear from the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, Ms. Gorski, if you can briefly voir dire your client regarding this recommendation and the belief that it's the best interest of the children at this point in time, please.
Yes. Please state your name for the record.
Haley Morales.
You heard the recommendation that Ms. Brower reduced to writing and the judge read into the record?
Yes.
Do you understand it?
Yes, ma'am.
Please speak up because we're making
Yes,
record.
ma'am.
Okay, thank you. Do you believe that this parenting time is in your children's best interest?
Yes.
You understand that the court still has jurisdiction, so if it doesn't work out, something else would be better, we can always come back to court. You understand that?
Yes.
Okay, and you are committed to continuing to facilitate the relationship between the children and their father, correct?
Yes, ma'am.
Do you have any questions?
I do not.
Okay, thank you.
Mr. Morales, can you please state your name for the record?
William Ernesto Morales.
Mr. Morales, do you understand this recommendation and agreement this morning?
Yes, sir.
Do you believe it's in the best interest of your children at this point in time?
Yes, sir.
All right, do you have any questions?
No, sir.
So this will take effect, Ms. Gorski?
Today. So that
Okay.
we are, he's going to have not this weekend will be my client's weekend, and he will have next weekend. So his first weekend will be November 28th. So right now we are in week 1. So he'll have Monday next week and Wednesday and then next weekend.
Okay, so I'll make sure you're on the same page. Understand that, Mr. Morales?
Yes, sir.
Okay, all right. I would like to thank.
Oh,
Ms.
I do
Brown
have a
for
quick
assistance.
question. I'm sorry, Your
Go
Honor.
ahead.
My apologies. If I was, so I have family that lives in like Findlay, Ohio. Is that an issue if I was to take them like to see my family on my time?
No.
Okay, I just wanted to make sure. I wasn't aware, and I've been told left and right from other people. I just wanted to make sure on my end.
Yeah, no problem. During your parenting time, it's totally fine.
Thank you.
All right, the court would like to thank Ms. Brower for her patience and assistance this morning. The court finds this agreement between the best interests of the children called adopt agreement, and thank you, Mr. Gorski. Mr. and Mrs. Morales, please communicate for the children's best interests. I mean, life, there's enough complications in life. Make good for each other and the children. The children sense when there's tension. You want to avoid that. Be flexible with each other. Communicate. All right, thank you. That will conclude this matter. Everyone can zoom out. Have a good rest of the morning. Ms. Brower.
Thank you, Judge.
Court, who's
Thank you,
corresponding recommendation. The recommendation is that the matter be adjourned to October 30th for plaintiff to retain counsel. Ms. Jenkins, haven't you had sufficient time to contact an attorney?
Yeah, well, I just moved into a new house, so things were kind of tight. So we're just waiting. But my dad's coming back into town this weekend. We're getting an attorney.
Well, that attorney needs, the court will grant one adjournment. So that attorney, you need to find an attorney that's going to be available for October 30th at 10:30. We're not going to come back and say, well, my attorney couldn't be there. I've got an attorney, but he can't be there at October 30th at 10:30. There will be no further adjournments. You understand that?
Yep.
Ms. Carr, how old is the minor child?
There are 2 children, Your Honor. They are, I believe, is it 9 and 2?
Yes, 9 and 2.
Yes.
Okay, and Mr. Morrow has no contact with the children. There's no, it's recommended that parenting time be reserved. Does he not have any contact with the oldest child over the past 9 years?
No, Mr. Morrow has frequent contact with the minor children. The parties actually were together for a lengthy period of time, and have recently, their relationship has ended. And Mr. Morrow has frequent contact with his children, which is in part one of the basis for the objection, as he is very involved in his children's lives.
But he failed to appear for the front of the court referee hearing. Is that why they recommended that his parenting time be reserved? He did not appear?
I'm sure that is probably why, Your Honor, and to his credit, he did attempt to adjourn that hearing because he knew he had a conflict, and then tried to call in, but it was too late. So yes, that is why I suspect the parenting time was reserved.
Very well. The court will adjourn this matter then to October 30th at 10:30. Ms. Jenkins, get that lawyer on board as soon as possible. But the reality is, you really want us, again, you wanted a stranger to decide this parenting time. I mean, you and Mr. Morrow should be able to communicate rather than advocate having a stranger make these decisions for your children.
No, definitely. I agree. I agree. It's it's just the
encourage you
child
to talk in
support.
the meantime. Can you talk this morning and reach your own agreement or not?
Yes, but I'm not sure if I can fully trust if it'll be followed through with. So
Well, if it's not, if it's a court order and he doesn't follow it, then you file a petition to modify it. Again, this court, just to let you know, why shouldn't you share joint legal? Forget about physical custody. This court does not even deal with physical custody. It's a matter of joint legal means, which means both you share equal any major decision concerning the welfare of your children, like elective surgery and education.
Yep.
Both need to agree upon those matters. And then it's just simply a matter of parenting time. I mean, you know your work schedule, you know Mr. Morrow's work schedule, you know what's best for your children. So I would encourage you to talk in the meantime. But this morning you cannot reach agreement. Is that correct?
Yes.
All right, matters adjourned to October 3rd at 10:30. That concludes matter. Thank you, Ms. Brower.
You're welcome,
Thank you,
Your
Your
Honor.
Honor.
Thank you.
You're welcome. For the record, this matter is before the court on the plaintiff's objection to a referee recommend order which denied her request to change school for the minor child from Custer to Summerfield. This hearing is being conducted via Zoom. It appears that both parties are present. You are Alyssa Collins, is that correct?
Yes, I am.
Joshua Rose, are you present?
Yes, sir.
All right, there's Mr. Rose. Good morning to both of you. Two of you have
Morning.
conferred this morning with Ms. Pratt for the front of the court. Mr. Pratt is recommending that referee recommend order be adopted. Ms. Collins, you have moved to Summerfield Township, and it's more convenient for you to transport your son to Summerfield schools rather than Custer.
Well, it's not just more convenient. It's a better school.
More convenient for who?
I said it's not that it's more convenient because of course, like having him in a school that's with his brothers and really close to home is going to be better than a school that, for me, of course. I'm willing to do transportation, and I said that. I was willing to help with anything that I needed to make sure that he goes to a better school. I'm not saying it completely has to be Summerfield School, even though I would like it to be Summerfield School because he has two older brothers in that school, and they have better programs and a 16-to-1 ratio for their student to teachers, which means he'd be getting more one-on-one programs. They have after-school tutoring on Tuesdays and Thursdays at the library. It's not just about convenience. It's about what's best for him.
That's what it should be. And Mr. Rose, you are opposed to your son changing schools from Custer to Summerfield. Is that correct?
Yes, Your Honor. And the convenience part of it and the routine of it, she'd already had a choice back in the day, and it was Custer. All my children go to Trinity School, and I offered Trinity School. It got denied because she said it was a religious factor. And then she turned around and she enrolled my son into a Bible study, which happened to be out of the St. James Bible, which was still the same Bible that Trinity Lutheran uses. And he doesn't even have to take do the religion classes there to obtain that school, but they have by far a way better for teaching. But it comes down to the parents because the teachers give them the lesson. Last week, whenever I had him on my time, or the week before, we got an 88% on his spelling. Last week, he went and he failed. He didn't even get one word right. I got the test sent home. And the different schooling and stuff. So really, it comes down to the parents
Hold on,
whenever
Ms.
it comes down to
Ms. Collins, you're interrupting. I can't hear both
I'm
of you
so
same time.
sorry.
Do not interrupt Mr. Rose, please.
I'm so
I'm
sorry.
sorry, Your Honor. I don't know where I got cut out at, but the moral of the story is I'm working with Christian and his spelling and his reading and stuff, and that's where he falls behind at, is in that area. The week that I had him, he had an 88% on his spelling test. Whenever he went back to his mom, I went to the court-ordered thing up there for his ADHD, which we have a review on the 14th of October with the doctors. And at that point in time, I asked him to spell some of the words because mom couldn't be in there. She was ill, having an allergic reaction. She did get the child there on time. And I asked him to spell some of the words that the teacher had sent me in a list. And he said to me, "Dad, we already did the words." And I said, "Yeah, how did you do the words?" And he said, "We did a word search. I'm all done with them." So I asked him to spell them, and he couldn't even spell them. So he was neglected at home whenever it come to the studying in the school curriculum. And that's where it matters at, to me, is it relies on the parents, not just the school. So she can't use that as a thing because it comes back to the parents. And if it has something to do with tutoring, they got tutors everywhere, not just at the school. Right. And they got other programs everywhere. It's just the neighborhood that she lives in. I live out in Erie. We're already transporting back and forth to Trinity. And that's the way that our system is set up for transportation and everything. And then it's going to make a bigger inconvenience for all of that transporting area.
Mr. Rose, are you willing to pay the tuition at Trinity?
Yes, Your Honor.
Are you willing to do all of the things that you need to do for it? Because I don't have the time for that. I have two other kids.
I already have two children in Trinity Lutheran, Your Honor. Willow
I have
and,
two children in
Collins?
Summerfield.
or
and
I have
understand.
three.
Ms. Collins, Mr. Rose is indicating that he'll pay all the tuition at Trinity. What about your son going to Trinity?
I don't agree with that. And we've
All right.
already discussed this and it's already been thrown out. And the
It
fact
can't
is,
be for religious
that-
reasons if you're doing Bible study out of St.
how
James.
can I talk
Sorry.
if you
I'm
interrupt
sorry.
me?
Sorry.
Go ahead, Ms. Collins.
It's not just Christian's reading. It's Christian's math. He is at a kindergarten level. Josh, you know I was profusely sick from something last week, and that's the only reason that Christian didn't completely pass the things that he needed to do. And that, you know what, that's my fault for being sick, and I apologize for that. I still, no matter what, even ending up in the hospital, made sure he got to that appointment on time. The fact of the matter is, yeah, it's an inconvenience for Joshua to have to, or Joshua's girlfriend, to have to drive Christian other places to go to school. And I understand that. It's an inconvenience for me to go to Custer at this point.
Very well, obviously, both of you as parents should work with your son. If in fact he needs a tutor, then the two of you should talk about it, a tutor. It sounds like Mr. Rose is willing to invest some money in the education of your son, even though it's a private school at Trinity. But if you two of you cannot agree, and Mom, it's your burden to convince this court that Summerfield is better, that there should be the best interest of your son to change school districts. School's already started. Christian's been in school for what, a month now? So you need to move on these matters sooner. Do it and file your motion in the middle of the summer. And but it appears that this whole motion was precipitated by your move to the Summerfield School District. So in any event, the court will in fact adopt the recommendation this morning that the referee recommend order is adopted. The minor child Christian shall remain in Custer Elementary until further order of the court. Again, if you want to renew your motion, file a motion next summer. Introduction line. What the court is interested in not is which school is better than another, is which parent is more actively involved in the schooling of the child. Who's helping with the homework? Who's going to parent teacher conferences? Those are the courts that the court is concerned about.
Then I disagree with it, because Josh is making it out to be like I'm not doing what I need to do as a parent, because the first week of school he didn't turn in his homework on Josh's week. I'm just not trying to badmouth the other parent. That's the problem. He wants to undermine me and make me sound like I'm not a good parent when I'm the one that's taking care of him for his entire life. And I'm sorry, but this whole court case was based off of a lie in the first place coming out of his mouth.
Okay, the court believes you're both good parents. The court's encouraging you both to work with Christian, work with his teachers, go to parent-teacher conferences, work with them every time.
I do everything that I need to, and I do not agree with this because you're making.
The court will adopt the recommendation. Christian will remain in Custer School to further order the court. We cannot have a conversation if you keep interrupting the court. So the court will enter an order to that effect. You can file a motion next summer if you want to again, the court to consider a change to a school district. We're not going to do it after school's already started. The court's not convinced it's necessary Christian to change school. So the court will adopt the recommendation to remain in Custer School to further order. That will conclude this hearing. You can both zoom out and be active, both of you, in Christian's education.
Yes, I agree. Thank you, Your Honor.
Okay, that will conclude this matter. You can both zoom out.
This is bullying.
For the record, this matter is before the court. The motion of the petitioner, William Doom Sr., to terminate a personal protection order entered in favor of his wife, Penny. This hearing is being conducted via Zoom. Is William Doom Sr. present on audio?
Yes.
Good afternoon. Is Penny Doom present?
No, she's not.
Okay. For the record, it appears that she has not appeared. This matter was scheduled for hearing at 1:15. It's now almost 1:30. Ms. Doom has not appeared. She's not contacted the court. Accordingly, Mr. Doom, the court is inclined to grant your motion to terminate this PPO. Do you have any questions?
Yes. Do you want me to talk now, or?
No, I just didn't know if you had any questions. The court is granting your motion. The court's going to terminate the PPO. Do you have any questions for the court?
No, I don't.
Okay. Now, you're still married to Miss Penny, correct?
Yes, I am.
Okay. You're still living together, correct?
Well, she left the house about 2 weeks ago.
Oh, okay. The address we have for her is 40.
That's my address, yes, and hers.
Are you separating?
I don't know what she's doing, Your Honor. I really don't.
Okay. In any event, Well, hold on 1 minute, I guess. I'm looking for a proof of service. Did you serve Miss Penny with a copy of this motion notice of hearing?
Yes, I did. Her and her daughter come over here, and I gave it to her daughter. I said, will you please get this to my wife, Penny Doom? She said, yes.
Okay,
So
sir, I'm sorry. The court's going to reverse this ruling. There's no proof of service in the court file. There needs to be a document in the court file that someone served her with this motion and notice of hearing. There is no such document in the court file. So unless you can get her to appear, the court cannot act without proof that she's been served and she was given an opportunity, that she was aware of this hearing today.
Okay, well, what should I do?
Maybe you can consult an attorney, but whoever served Miss Penny, you said it was another family member?
Yes, her daughter.
That person needed to sign an affidavit that the person who served Penny needed to sign a proof of service.
Right. I didn't look back even over. I don't know if she took it with her or what, Your Honor.
Well, but the court, Mr. Doom, the court needs a document in the court file. It's called a proof of service. It's an affidavit signed by the person who served Penny Doom, saying, I, Joe, whatever, personally gave Penny Doom a copy of Mr. William Doom's motion and notice of hearing. So since there is no proof of service in the court file, the court will have no alternative but to deny your request to terminate. So if you want to, you can come down to the clerk's office, you can file another motion, a new hearing date, and you need to serve Miss Doom, and you need to have whoever served her file with the clerk of the court a proof of service.
Okay. So what happens with this one that I got in front of me, this PPO?
It'll continue. The court is denying your motion to terminate because there's no proof of service of this motion of hearing upon Penny.
Okay. So I come back to the courthouse and file another one?
And most importantly, once you get a new hearing date, you need to serve that with Penny. And the person who serves it needs to complete a proof of service. If you don't know how to do it, then you can ask the PPO window. Otherwise, you could talk to an attorney. But since there's no proof of service in the court file, the court will deny your request to terminate this because Miss Penny has not appeared. Now, if she would have appeared today, even though no proof of service, we could have gotten her input. But there's nothing in the court file to reflect that she was aware of today's date and time for this hearing.
Okay, Your Honor.
So the court will enter an order denying your motion terminates, but you can refile your motion.
Thank you.
You're welcome. That'll conclude this matter, Mr. Doom. You can zoom out, hang up, and have a good rest of the day. Thank you.
Thank you.
You're welcome. For the record, this matter is before the court on the plaintiff's motion to enter a default judgment of custody. This hearing is being conducted via Zoom. Present is attorney Corey Shimmick, representing the plaintiff, mother Alyssa Johnson. Ms. Johnson is not present. The court's informed that she was hospitalized this morning. However, the defendant, Timothy Westmoreland, is present. Mr. Westmoreland, you've not appeared numerous times. So can you please state your name and your mailing address for the record, please?
Timothy Westmoreland, 5'9".
Mr. Westmoreland, did you receive the proposed default judgment of custody?
Yes.
Okay. Why should the court not enter that today? Because you've repeatedly failed to appear. You didn't file an answer to the complaint. You've failed to appear at least 2 times in the past. Why should the court not enter this?
I have no idea.
All right. This gives mother and sole legal and physical custody of their 7-year-old child. Parenting time. This order provides you have parenting time every other weekend during the school year and week on, week off during the summer. Do you currently have any contact with your son, Miles?
Yes.
Is that what you're doing? Are you practicing every other weekend?
Yep.
Okay.
And last year was every weekend.
Okay. Again, so you don't know why the court should not enter the judgment. If in fact you're problem with, you can always file a motion to set aside the judgment. But you've failed to appear numerous times. It's creating unnecessary expense for Ms. Johnson, and it's taken a lot of this court's time to get to this point. Mr. Westmoreland, are you opposed to the court entering this judgment? You've received a copy, reviewed it. You've had a chance to talk with Attorney Shimmick this morning. Are you opposed to the court entering this judgment?
Yes.
Okay, and what are you opposed to? What are you opposed to?
I just want 50-50.
So you're okay with the custody order? You just want 50-50 parenting time, is that correct?
I want 50-50 custody. And like everything else is fine.
Okay, so you're fine with the parenting time?
I'm fine with the parenting time and everything else, but the custody, I want 50-50.
Well, Mr. Shimmick, this court does not get hung up with this title of physical custody. As far as this court's concerned, I mean, if Mr. Westmoreland has been actively involved in the life of this child, I'd have to be convinced why the court should not order joint legal, so the parties can share equally any major decisions concerning the welfare of the child, like elective surgery, education. And it's just really about joint legal and parenting time. So it sounds like if in fact Ms. Johnson would agree to joint legal, forget the word physical, Mr. Westmoreland's agreeable with everything else in his judgment.
Your Honor, what my client has communicated to me throughout this case is that the reason why she wants sole legal custody of the minor child is because Mr. Westmoreland has not taken an interest at all in any of those decisions in the minor child's life since he's been born, including his schooling, any type of medical decisions, anything like that. It's always been on her shoulders, and he has never offered to help or been interested in or wanting to participate in any of that. And it's been totally on her to do all of that. And she would like it to continue to be that way because she's the one who has been responsible for doing that and keeping up on it all in the past since the minor child has been born.
All right. Mr. Westmoreland, have you taken your son ever to the doctor, the dentist?
No, I have not. She won't let
talk to his teacher.
She won't let me. She never told me anything.
Oh, hold on. Well, what's she doing? Is she preventing you physically from talking with the teacher or the doctor?
She won't inform me of any parenting teacher conferences. She never informed me of any doctor.
Hold on, Mr. Westmoreland. She doesn't need to. You have a child in school. Do you know where the child's in school?
Yes, I know the child's in school.
You contact the school. Make sure that you're listed as contact information. That's something you can do. You don't need mom's permission to do that. You should list as emergency contact. In the event the child is ill or gets injured at school and they can't reach mom, they should be able to reach you. Well, and then when you're hold on, Mr. Westmoreland, when you're on that list, and you'll get notices of all the parent teacher conferences and report cards. You need to contact the school and make sure you're listed as a parent. You'll get all the information. You don't need to get that from Ms. Johnson.
Yeah, but that doesn't help me with like doctors and stuff. I get what you're saying, but also if they don't know that I'm the father, then they ain't going to give me just the information too. You got it.
And Your Honor, Mr. Westmoreland could have reached out to myself if he really wanted to have access to any of this. He's had my information for a long time, and this is actually the first contact that I've had with him in this case is today. And I haven't heard anything from him regarding wanting access or my client attempting to prevent him to have access to any of that information.
Mr. Westmoreland, are you going to hire an attorney?
I don't have enough money to hire an attorney.
All right. Well, you've acknowledged not having played an active role in your son's life. You've not participated. This is the first time you've appeared. You've not reached out. You've created unnecessary expense for Ms. Johnson. At this point in time, the court's going to enter the proposed default judgment of custody and parenting time. If you have an issue about that, you can file a motion with the court to modify that. But you have a right to know where the child's doctors are. If you're going to hire an attorney, I'll give you a continuance, Mr. Westmoreland, one continuance. But I mean, we're not going to. If I adjourn this matter,
sure,
odds are you will not appear.
Mr.
Westmoreland,
you have the power. Do what you want, sir.
Well, again,
you have
convinced the court that you're interested in that you're going to appear in these court cases. You've shown to the court, and I'm in a disinterested party. You've shown the court that you're not interested in the welfare. You've not appeared in any of these court hearings. There's been at least 3.
Do what you want, sir. You have the power.
Well, I'm trying to get some input from you as a father, Mr. Westmoreland.
I'm in the kid's life. I've been in the kid's life.
Why haven't you appeared in court?
I haven't received any other notice about a court date. I showed up to the referee like a couple weeks ago.
Hold on. Mr. Westmoreland, you say you've never received any notices?
I didn't receive any other notification about anything else. I received
Hold on.
Things after.
Go through the history of this case.
But
there was a complaint for custody filed by Ms. Johnson back in March 12th of 2024.
Yeah. Papers after it was
Hold on. You were personally served with a copy of all those pleadings on March 13th, 2024, 12:55 p.m. on Superior Street. Copy of the complaint for custody.
Do what you want, sir. You got the power.
I'm just asking you, Mr. Westmoreland.
Just do what you want. You got the power. If you want to give her sole custody and let her.
Hold on. You said you didn't receive any of this, Mr. Westmoreland, and if you did not receive these pleadings, then the court's going to adjourn this matter. I'm asking you, did you?
When you guys already made the judgment, I did not receive the date of the court. I asked her for the court date. She did not give it to me. She called me the day of court and said, "Why are you not here?" That's the type of stuff.
Your Honor,
let's take one step at a time. You were served with a copy of the complaint for custody on March 13th. And that summons said you got 21 days in which to file a written answer. You did not file a written answer, but do you acknowledge receiving a copy of the complaint for custody, Mr. Westmoreland?
No. If it had a court date, no. If it did not have a court date, then I probably did. And I don't know.
It did not have a court date, but it was a legal notice that said you have 21 days in which to file a written answer. You didn't do that. So then what happened, let me go through the file, is that Mr. Shimmick filed a motion to establish the interim child support. And that was scheduled on May 28th, 2024 at 3 p.m. And that was mailed 24. We waited the 15 minutes for you.
Bringing me through the dirt, man. Just if you're going to do it, do it.
And you were mailed a notice of that on April 8th. We're hearing on May 28th. So that was a hearing you had like 6 weeks advance notice, Mr. Westmoreland. Mr. Shimmick, were any of these mailings to Mr. Westmoreland being returned as being undeliverable?
No, Your Honor.
Okay, so that was May 28th. And then the next thing in this matter, on May 28th, the court entered an order for child support. Have you been paying any child support, Mr. Westmoreland?
No, I filed for Social Security. So I don't have nothing at the moment.
Well, does the child receive Social Security?
No, I just filed for Social Security.
Okay. Okay, so the answer to the court's question, you've not been paying child support, correct?
Yeah, I already talked to the referee a couple weeks ago about that.
Okay, and the court file reflects that on May 29th, the copy of his order of child support, or you pay child support of $377 a month, was mailed to you on May 29th, 2024. Did you receive that order for child support?
Mm-hmm.
I'm sorry, is that yes?
Mm-hmm.
Is that yes or no?
Yep.
Okay. All right, so you received that. And then thereafter, Mr. Shimmick filed a motion to enter a default judgment of custody. That was set for hearing on September 18th, 2024. A copy that was mailed to you back in April. Copy of the motion to enter default judgment of custody. Notice of hearing, proof of service. Mr. Shimmick thereafter adjourned the matter. The clerk entered a default against you on August 16th, 2024 for your failure to answer the complaint. It appears that you were mailed a notice to appear before the friendly court referee McKee on September 25. Did you appear before the referee on September 25 for your failure to pay child support?
Yep.
Okay. Again, that was for the friendly court referee. So this matter was adjourned to today's date at 1:30. This is the first time you've responded, Mr. Westmoreland. So what do you want to do, Mr. Westmoreland?
I want 50-50.
Okay. Are you going to hire an attorney?
I ain't got no money to hire an attorney.
All right. All right. Ms. Brower, the court's going to enter an order today referring the issue of custody and parenting time to the front of the court for formal investigation recommendation, please.
Yes,
We'll
Your
give
Honor.
Mr. Westmoreland one more opportunity. Mr. Westmoreland, you need to file a motion to set aside the default. You need to take action. Go online. You need to figure out what to do. You just can't sit back on the sidelines. So the court's going to enter an order today. I'm going to refer the issue of custody and parenting time to the front of the court for formal investigation recommendation. And you got to be proactive. If you're not paying child support, you need to file a motion to reduce your child support. Don't sit on your hands because that support is piling up at $733 a month. And you can't retroactively modify that. So if you don't have the income, you're unemployed, you're injured, you're incapable of employment, you need to file a motion to reduce or modify your child support. You can get those forms online, talk to the front of the court caseworker. You got to be proactive, Mr. Westmoreland. Because otherwise you're going to you're digging yourself a hole, $733 each month until you file your motion.
Your Honor, may I ask?
The front of the court's going to mail out a questionnaire to both Ms. Johnson and Mr. Westmoreland, and both parties need to answer that. Then, Ms. Brown, will there typically be a phone interview then?
Yes, Your Honor.
We have a 7-year-old child. And Mr. Shimmick, anything further?
Your Honor, I would ask Mr. Westmoreland if he could give me a phone number that I could contact him at so that I can reach him.
Mr. Westmoreland?
Yeah. You need it now?
Yes.
Yes.
313. It's my house number.
And Your Honor, if when I speak to my client and if the parties end up having an agreement in this matter and we have a signed consent judgment, would we be able to simply submit that, or would you want us to appear to take any type of proofs?
No, I don't think we need to take any further proofs. At first, I was confused. I thought maybe it was a mention of a default judgment divorce, but it's not. So I don't think we need any further proofs. I think the parties' signature and approval of a consent order would indicate their consent. They believe it's in the best interest of their child, that the parties that the order is in the child's best interest. So even if we, so we'll take one step at a time.
Okay. All right. That is my intention, Your Honor, to hopefully have a consent judgment signed. And if we do, I will submit it to the court and hopefully we can get this matter resolved.
So, Mr. Westmoreland, you simply want joint legal custody. Is that correct? And you're okay with the parenting time?
I mean, for right now, yeah, because that's just fine for me right now. I just want 50.
Parenting time to be modified. And with joint legal, Mr. Shimmick, if your clients, if they're the child's going to the emergency room, all you got to do is notify him. And again, if he wants to participate, show up, or if he asks questions, then so be it. If he doesn't, then so be it.
Yeah, understand, Your Honor.
Mr. Westmoreland, he can sign up, get all the contact information from school, but yeah, mom should let him know who the doctor is, who the dentist is, and just keep him generally informed. If he chooses not to participate, and he look on decisions, so be it. So in event, Mr. Shimmick, if in fact there's not a consent order, if you could renotice the matter for hearing, the default judgment, if Mr. Westmoreland has not filed an answer or taken another action, you can renotice that for entry after the front of the court issues its formal report and recommendation regarding custody and parenting time.
Okay.
Or do you want to hold off on that? Do you want to hold off on going through that process to see whether your client, is that something you can recommend to your client? I hate to waste the front of the court's time on that. Parenting time, I guess, is not an issue.
I think we can hold off on that, Your Honor. I am fairly confident that we will have a consent judgment to present to the court in this matter.
All right, we'll strike that then, Ms. Brown. We will not refer it at this point in time. So let's just put it over for a couple weeks. Mr. Shimmick, you can talk to your client. Hopefully, he gets out of the hospital. You can communicate with Mr. Westmoreland. Mr. Westmoreland, if you get a phone call, Mr. Shimmick, return his phone call. We just want you to, if you're going to participate, just don't play games, please.
I'm not. I mean, I don't even know if you guys had my house phone, but I got an answer machine. Leave a message if I don't get it.
You have a home address. You're not checking your mail, sir. You need to respond.
I live here, so I don't know. Anybody could grab it. I'm not the only one that lives here, sir.
Okay, so let's give it. We're going to set this for a continued motion hearing. Yeah. That's fine.
Okay. I have October 24th at 1:15.
Are you available at October 24th at 1:15, Mr. Shimmick?
Yes, Your Honor.
Okay, that's 2 weeks. Will that be enough time to communicate with Ms. Johnson and get Mr. Westmoreland into your office to approve something, or you can perhaps even sign electronically?
Yeah, yes, it should be, Your Honor. Mr. Westmoreland, do you have an email address also that you could give me?
Yeah, it's my full name.
Right, this matter is adjourned to October 24th at 1:15. The court will allow notice to Mr. Shimmick and to Mr. Westmoreland. So, Mr. Westmoreland, make a note right now. If you're not getting me October 24th, 1:15 Zoom.
Okay.
You must appear.
I will. I promise.
All right. All right. Thank you, Mr. Robert, Mr. Shimmick. I will close. Ready to Zoom out.
Thank you, Your Honor. Have a great day.
Okay.